started even as we have a few stragglers coming in and finding space. Good morning. My name is Ryan Mulvey. I have the pleasure of serving as the president of the American Society of Access Professionals. Thank you very much for joining us today for this special symposium that marks and celebrates the 50th anniversary of the 1974 Freedom of Information Act amendments. Both personally and on behalf of our board, we are very excited for today's event. We haven't done a symposium in a while. This is something we've been trying to put together, and we're honored to have partnered with a number of groups to make this a reality. I want to, first of all, recognize the attendance of several ASAP past presidents, Miriam Nisbet, Patrice McDermott, Harry Hammett, Kirsten Mitchell, and Ann Weissman, who are all here with us today. This program was developed from several different interests that happen to all come together. As I mentioned, ASAP has been looking to host a symposium of some sort. Tom Sussman, in the back there, was trying to put an event together to mark the 50th anniversary of the 74 amendments as well. And Ann Weissman, who co-teaches a FOIA clinic here, was also hoping to do something on the amendment. So we all got together and helped make this a reality. I want to especially thank then Tom and Ann for your assistance, along with Claire Shanley, our executive director at ASAP, for our many calls and the work individually to get the speakers together and the funding and the space. I'd like to thank GW Law and the Brechner Freedom of Information Project, who are some of our main co-sponsors. Also thank the University of Florida College of Journalism and Communications for its generous support, along with Essential Information and the Center for Responsive Law. Finally, I want to thank the Project on Government Oversight and the National Security Archive. The support from all these groups is greatly appreciated and demonstrates how FOIA is important to so many of us. I also want to draw attention to the statement from Ralph Nader here. Tom, later today, will speak a little more in depth about this, but if you haven't had a chance to glance it over, there are copies at the registration desk, and there's some important words there from Mr. Nader. This is also an extra special day because we're sharing this symposium with students from GW Law. They represent the next generation of lawyers and also, hopefully, public access professionals. The job fair that we have here, we hope they find interesting and compelling. We also appreciate the agencies who are participating in that job fair. We have OGIS at NARA, the Department of Defense, the National Institutes of Health, CBP, OIP, and the FAA. We encourage meaningful dialogue during this program and look forward to your feedback. After the end of the symposium, Claire will be sending around a link to a program survey. We appreciate your feedback, and we can also email you a certificate of attendance. Finally, we are recording. We're not broadcasting, but we are recording this for posterity's sake, and we'll likely post it on our YouTube channel sometime in the future for the benefit of those who weren't able to attend in person. Without further ado, then, I'd like to turn it over to Dave Coulier for the first panel. Take it away.
Thank you, Ryan. Appreciate that. And thank you, Claire, and everybody at ASAP, Tom Sussman, for getting this going. This is a great day. And I want to thank the Brechner family, too. They're the ones who funded this, and Burl Brechner, who is a proud GW alum in journalism. So that's kind of a connection here. This first panel, what we're going to try to keep it casual and conversational. Nobody likes to be lectured at for an hour. So what we'll do is we'll go in order with Lauren and then Alan. And as they talk, maybe some of us will interject, ask a question, And I'll be moderating, and if someone has a burning question and wants to chime in, just raise your hand. And if I have an opening, I'll call on you, and we'll have a conversation, not just, and still save up questions for the end if people want to have discussion. So that's going to be the format of this panel anyway. And with that, I'd like to introduce my fellow panelists, Lauren Harper. She's the Freedom of the Press Foundation's first Daniel Ellsberg Chair on Government Secrecy, established to honor and continue the whistleblowers' fight for secrecy reform. She joined the organization after a decade fighting secrecy with the National Security Archive and with Tom Blanton and good folk there. She was public policy director and helped historians, journalists, and the public win the declassification of significant government documents. She holds a master's in public policy and a master's in Middle Eastern studies, both from the University of Chicago. And she also served on the previous term of the Federal FOIA Advisory Committee with some of the folks in this room, Jason R. Barron and others. So, and we do have folks from the Office of Government Information Services here as well. Thanks for coming, from NARA. Alan B. Morrison is the Lerner Family Associate Dean for Public Interest and Public Service here at GW Law. For most of his career, he worked for Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972. And he directed for over 25 years. He's argued 20 cases in the Supreme Court, including victories in Goldfarb v. Virginia State Bar, holding that lawyers subject to the antitrust laws for using minimum fee schedules. Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council, making commercial speech subject to the First Amendment. And I and many others still teach that case in media law courses, a very important case, as well as many others. He currently teaches civil procedure and constitutional law and previously taught at Harvard, and NYU, Stanford, Hawaii, and American University Law Schools. He's a graduate of Yale and Harvard Law School, served as a commissioned officer in the U.S. Navy, and was an assistant U.S. attorney in New York. So two very esteemed folks here today, and it's going to be fun.
We get to introduce you, Dave?
I was going to say I need no introduction, but that's really not true.
Oh, well, we need to give you some encomiums.
I'm really just an unknown, southerner up from Florida here today. I am director of the Breckner Freedom of Information Project at the University of Florida, which has been around since 1977, doing research and education and access to government information. Before that, I was at University of Arizona 17 years teaching access to public records and whatnot, doing research. I was a journalist in a previous life, covering government. That's what interested me in this. And, I just think it's important stuff. I'm maybe one of the few people in this room without a law degree, nor an interest in it, getting one. Instead, I went that other piled higher, deeper route. So that's me in a nutshell. Thank you. All right, so let's get going. This session is to kind of give the big overview of why all this is important, right? And Lauren is going to start us off, and then Alan, and then I'll clean up. I do apologize if I interject to keep things moving along. We want to have as many voices heard as possible, and that includes from y'all. So let's get going. Lauren, take it away.
Thank you very much. I have to say it feels a little strange sitting up here, especially without a law degree, but here we are. It's probably the only time I'll ever be up here. Our panel is tasked with talking about the importance of transparency in a democratic society, which is a tall order. And I think one of the reasons it's challenging is because transparency and its impacts can take a lot of different forms, as can transparency's inverse, secrecy, that can look different depending on the context. And it could be sometimes hard to quantify and explain in a way that shows concrete damage. But I think in this instance, one of the best ways to really show how important transparency is to our system of government is to provide a few concrete examples of how it impacts us on the human or day-to-day level. And one of the biggest areas where I think transparency can have a tangible impact is human rights. And FOIA has actually been one of the most important and consistent tools to win the release of human rights information. And there was a really great recent example that came out of the New Yorker earlier this year. Their investigative podcast series, In the Dark, had a series on that revealed war crimes committed by United States military personnel since 9/11 in Iraq and Afghanistan. And the reporting relied on a FOIA lawsuit to build a database of literally hundreds of instances of war crimes committed by U.S. troops that largely went uninvestigated and unpunished. And to the extent there was occasional punishment, it was mostly administrative slaps on the wrist, indicative that the U.S. Military is not taking this seriously. And some of the most impactful documents that they got released through this FOIA lawsuit was actually photographs, particularly photographs of the Haditha massacre, which took place in 2007 in Iraq. And when I saw these pictures, it reminded me of the long tradition of using FOIA to win the release of evidence of human rights crimes, including the U.S.'s torture programs. For example, I think the most infamous photos probably come from Abu Ghraib, aspects of which are still being litigated. So U.S. documents declassified through FOIA have been used in international criminal courts to prosecute military officials who carried out mass disappearances and political assassinations in Latin America as part of Operation Condor. Dave mentioned I'm an alum of the National Security Archive. They've really done fantastic work over the decades winning the release of these kinds of documents. If you're at GW in particular and you haven't been, I suggest walking over to Gelman Library and checking them out, or visiting their website and looking at this documentary evidence that's been used to tangible impact in international criminal courts. Also used, these declassified U.S. documents were also used in the trial of former Peruvian President Alberto Fujimori. So there's been real tangible impacts from the use of FOIA, I think, both to show what abuses the U.S. government was committing and also what the U.S. government knew other nations were doing that was wrong and they weren't doing anything about. But of course, FOIA plays a big role in domestic policy issues. I think some interesting things that have come to light recently show how FOIA has shed light on agencies' use of things like facial recognition technology. There was a recent story earlier this year showing that an immigration agency was developing a policy of using controversial facial recognition technology to track minors who had been detained as they age. And on the local level, FOIA has also been used to show police forces using facial recognition technology when making arrests, but not disclosing that information, which can have impacts down the line. But FOIA also just has an impact on just a whole host of domestic policy issues. Basically, if it touches your life in a way, FOIA has been involved in some shape or form. I think a big and perhaps underappreciated area where FOIA plays a role is public health. It's won the release of information not only on COVID, it's also played a role in the Flint, Michigan water crisis. It's also been used to win the release of information on climate change policy, also information on how the U.S. government both prepares for and responds to national disasters. All of that has been released to FOIA. And a somewhat funny FOIA release that I want to highlight before moving on is there was a FOIA request a couple years ago to the Food and Drug Administration seeking information on the ingredients of a popular Parmesan cheese, topper. You put it on your salad, you put it on your pizza, whatever. The FOIA showed that there was absolutely no Parmesan in this cheese, but it did contain wood chips. Now, this is kind of funny, right? But if you think about the context that we're in right now, perhaps going into an area of decreased regulation, you can see very quickly how public information to things like food safety information gets very serious very quickly. So FOIA has an impact not only on the democratic process, but I think also on the decisions that we make on a daily basis. On the flip side, I want to take the opportunity to talk about transparency gaps that don't always neatly align with FOIA and that I think we need to pay attention to as we consider where FOIA goes from here. One of the biggest ones, I think, is overclassification. FOIA has an exemption for national security information, but this information, the way it's defined, how it's handled, and how it's downgraded is not covered by statute. It's actually covered by an executive order. The current one is Executive Order 13526, which dates to the Obama administration. and it currently allows far too much information to be technically classified. It makes it very difficult to obtain this kind of information even through the FOIA. We also have records management issues, which I know the folks at OGIS appreciate, but I think beyond that is somewhat underappreciated. But we also have instances where agencies may be following their proper records retention schedule and destroying records before anybody can file a FOIA request in the first place. A good example of this is the January 6 text messages that were destroyed by the Secret Service, which was allegedly in accordance with their records retention schedule. And we also have issues surrounding presidential records, which I know a lot of folks in this room care about, but we have the potential for having a future president coming in who has shown disregard for maintaining, preserving, and providing access to their presidential records, and that includes holding up transparency norms like access to the White House visitor logs. And I think about that, and I think about how valuable it would be for us as a soon-to-be voting public to know, for example, who was visiting the Trump White House between the loss in November 2020 to the attempt to prevent the peaceful transition of power January 6, 2021. That kind of information would have been good to know quite a long time before, especially as we're about to vote. And so I want to close just on this note. You know, it's not lost on me that we're here today to celebrate the 1974 FOIA amendments, which came about during a very tumultuous time in U.S. political history and on the heels of the Watergate crisis and the excessive abuses and secrecy of the Nixon administration. And we find ourselves now, I would say, in an equally tumultuous period of our political history, and on the proverbial eve of an election that I think will determine, you know, not only what transparency looks like going forward, but what our participation in the democratic process looks like and what government accountability actually looks like. So I think it is the right time to be celebrating FOIA, thinking about how we can strengthen it, because it is really the strongest tool that we have, not only to hold our government accountable when they are doing things that are unlawful, but also things that we believe are counter to our national character.
Great, thank you, Lauren. Ellen, did you want to chime in on any of that?
No, I'll just chime in on my old stuff.
All right, let's do some chiming.
Thanks very much. Before I begin, I want to note the absence because of this recent passing of David Burnham. David took FOIA to a new level. He took it to a level that wouldn't have been unthinkable literally in 1966 because we didn't have computers and we didn't have the access to information, and the government didn't keep these computerized records. But David started this project at Syracuse in which they went ahead and took all this data that the Justice Department had that nobody else was looking at, nobody else had a potential for looking at it, and he turned it into a brilliant set of activities that exposed what the Justice Department was doing and what it was not doing. And so I just wanted to acknowledge David here today. He was a client of Public Citizens for many years in many situations, but that's not why I'm here. Of course, he was also a fabulous reporter beyond that as well. All right, so let me begin in 1966 with a word of praise for Lyndon Baines Johnson. He signed FOIA over the objection of virtually every federal agency in the country. As I've said in other contexts, no civil servant ever got an award or promotion because they released documents pursuant to FOIA requests. It's quite the opposite. Everything they can do to keep them quiet. Johnson knew the importance of this, and he signed this into law. I'm glad to see that we have agency representatives here. I'm sorry that most of them are out there instead of in here listening to what we have to say, but you know that's life. FOIA has a single proposition: everything is public except. It didn't apply to Congress, because no big surprise there, or not to the judiciary because, quote, everything important is in our final opinions, also wrong. The key ingredients: anyone could make a request. As Victor Kramer, who ran a FOIA program over at Georgetown, said, the Shah of Iran in those days, and I would say Vladimir Putin today could make a FOIA request and they would have to answer it, although they probably wouldn't. The right to get everything with specific, more or less narrow exceptions. And contrary to the Administrative Procedure Act, the burden of proof was on the agency to justify its withholding, and you didn't have to have standing, and you could go into court right away as soon as you made a FOIA request. And there was at least in theory, de novo review. That's the theory. Of course, as we learned quite quickly, that was not quite how it worked in practice, both at the beginning, later, and then even today. I litigated my first FOIA case as a co-counsel when I was an assistant U.S. attorney in the Southern District of New York. And the first case that came to our office, a FOIA case, was a case in which, I can't remember who it was, made a request to the Veterans Administration to get the test results on hearing aids. This was something that veterans absolutely needed to have. Everybody needed to have. Which ones worked and which ones didn't work. And the agency refused to turn them over. They were confidential commercial information that they had. And at that moment, that was when I understood what the battle was going to be about. Fortunately, a sensible district judge rejected it, and there was no appeal taken from it. But that gave me my start, and I now refer to myself as a founding FOIA litigator. I came to Public Citizen in early 1972, and almost immediately we had FOIA cases. This was one of Ralph's great understandings that FOIA was a tool for all of his advocacy work, and we hired somebody to do, Ron Plesser, to do FOIA cases immediately. We had our first case, as I remember, was an amicus brief we filed in the D.C. Circuit involving an issue that hung around for a very long time, and that is whether the FDA had to release the test data for its safety and efficacy of the drugs, which finally got changed after many, many years. The case was in the D.C. Circuit. But we litigated on behalf of Public Citizens, various subparts, and related organizations, the Center for Auto Safety, Aviation Consumer Action Product, et cetera. To give you an idea what we were up against, of course, everybody could make a request, and everybody had the equal right to get the answer to be no all the time. In about 1973 or 74 probably, we had 1.5 lawyers working on FOIA cases, and the government had a list of all the FOIA cases, and our office had 25% of all the litigation going on in the country at that time. So you can understand what's happened in the meantime. Ralph went to a hearing on FOIA. This was before the amendments got going, and he was asked, I think it was in the House, he said, "Mr. Nader, which is the worst agency?" Ralph looked at him and he said, "Knock on any door." They were all the same in his view, and I think he's probably right about that. I think of all our early victories, the most significant victory was not on the merits of getting the documents, but it was a procedural victory. Bob Vaughn, who was then working for Ralph studying civil service and is now a retired professor at the American University Law School, made a request to get the reports from the Civil Service Committee study on various supposed bad practices and needs for reform. He made a request, and the government came in, and I think the only exemption they didn't claim the banking exemption, the oil and gas, and exemption 1, but everything else that they claimed in a blunderbuss fashion. That is, you couldn't, without prescribing, they said everything is covered by everything. And so the district judge ruled against us, and we went to the Court of Appeals, and we had a very conservative judge. Malcolm Wilkie was on the panel. Wilkie had been in the government, and he knew what was going on there, and he just understood that not only we were supposed to have access, but that you couldn't litigate cases this way with the government throwing everything in. And he literally created out of his own mind the Vaughn Index, requiring the government to do what you would do in an ordinary litigation, which is, all right, it's not exempt, which exemption, which parts, and so forth and so on. And it was a fundamental revolution in being able to go after government records. In the end, came back, we got most of the records, we got all of the criticisms, we didn't get the recommendations, but from the criticism, you could tell what the recommendations were as well. Then we had another case. We represented Carl Stern, who covered the Supreme Court and legal matters for the Justice Department. The first interesting thing about this is back in 1972 and 3, none of the television stations, newspapers had any notion that they were going to have lawyers who were doing these cases. And so Carl came to media people at the time, because the NBC wouldn't want to spend their money doing FOIA cases to hire lawyers. He had heard about this program of the FBI called COINTELPRO, which many of you have heard of. And so we made a request. The good things that happened to make this request a victory is that J. Edgar Hoover had died before then. Watergate was going on. Elliot Richardson was the Attorney General, and Watergate was going on at the same time. And Ron Plesser won this case in the district court, and Elliot Richardson said no appeal, and all these records came out. Unbelievable records about human rights and civil rights abuses, all made possible. I remember we had another wonderful case, Clarence Ditlow's Center for Auto Safety. Clarence made many requests to the Department of Transportation. And he was one request in there, and we were before Judge Aubrey Robinson. Robinson said, let me see these documents in camera. So he gets the documents in camera, and he rules for us in favor. And he says, the first thing I don't understand, it's not clear why the plaintiff wants these documents at all. He said, but given the vigorousness with which the defendant is refusing to turn them over, that probably ought to be enough to explain why the plaintiff wants to get them. Give him the documents. And so he did. And of course, that was what was going on all the time. Many times we got documents, and the question was why they were fighting about them to begin with, and was it worth it at all? So not all was rosy at the beginning, as you'll hear this afternoon in Tom Sussman's rendition of the 1974 amendments. Exemption 1 was being used in a manner that anything, as long as it had a classified stamp on, nobody could get access. De novo and a review didn't mean anything. Nothing else meant anything. Exemption 7, it was written in terms of law enforcement files. If you put it in a file that was labeled law enforcement, it was automatically exempt, no matter whether the harm was or anything else. No matter what was going on, it was automatically exempt. And so in those days, Congress was actually available. Congress was in the business of solving problems. They had people on the Hill who would listen to your problems, and we went up there and talked to them, and they fixed both of these. Exemption 1, they fixed it better, but it's still a big problem. But actually, even though nobody has ever actually won an Exemption 1 case when the court has actually said that the existence of the review has made it very possible that when you get there, the government will do, this is the government's typical response. Okay, you can have these documents, but these are really secret. And so we get something as opposed to getting nothing. Exemption 7, don't get everything, but get a lot more, and they really are tied to the specific reasons for getting it. The statute also gave attorneys' fees, which was very important for everybody else. One other example I want to give you about how Congress was available and how the agencies were actually available. Many of you know Tom Field, who ran tax analysts and advocates in taxation without representation for many years. We represented Tom in a number of matters. Bill Dobervier, who did a bunch of FOIA cases, also represented Tom in cases to get access to these very important IRS ruling letters and general counsel's memorandum and other things, which were really where a lot of the law was being made at the IRS. And there were cases going on back and forth, and the IRS was fighting it. And the Joint Committee on Taxation decided it wanted to have something to do with this. It wanted to look into this. And I got a call, and they said to me, we're having a meeting up on the Hill on a Saturday. Would you come up and help us mark up this bill on what's going to happen? And we had people from the IRS and Treasury there. We had Tom and his people there. We had the people from the Joint Committee. And we sat down and we went over and we reached what was considered to be by everybody a fair compromise, understandable. And we just did it in those days because people wanted to do what was right. And the Congress understood that it was responsible for seeing that the executive branch was reined in. The last I want to talk about, and didn't happen at the very beginning, was at the beginning of the Clinton administration. George H.W. Bush had tried to issue an order deleting all the electronic records, emails from the files. The ACLU started the case and almost immediately turned it over to us. And the issue was, are electronic records within the meaning of FOIA, or were they, as the official statements came out, said, look, we print out everything that matters, number one. And number two, the only things that don't count are messages, can you join me for lunch? Everything else nothing was there. And what's the big deal about all of this? And we took this case. Michael Tankersley did a magnificent job with it. We didn't win everything. The National Security Council was considered to be part of the president for presidential records purposes. But that changed everything today. That victory of saying that electronic records, of course, are records, and they have to be subject to the FOIA. And so that was a very, very big thing. Now, let me give you one personal example of where the FOIA has fallen down and where, if I could do it, be my next big project to change it. And that is, if you think about, actually, what got me thinking on this was the discussion about human rights violations that have been uncovered. In too many of these cases, the human rights violations have been uncovered because they have been authorized by lawyers, including lawyers in the Office of Legal Counsel that authorized torture. There is no more important legal work done in the government today than at the Office of Legal Counsel, which has been true for decades. They have the final word. The memorandum by David Barron says it. We have the final word. Agencies have to follow what we say, and they do. Not only do they do it, but they also get permission if they've done something wrong. If the OLC has said it, nobody's going to prosecute them. The OLC has taken the position that OLC knows best, and we will give out what we think is important and useful for you. And don't worry, we understand what's important, and you'll get it. Well, I don't think that's usually the way we think about FOIA and the government, but that's the way OLC has done it. And I affirm that everybody, the executive branch as a whole, has given into that official position. They claim it's attorney-client work product, it's attorney-client work product privileges, it's deliberative process, it's everything. I, along with Ann Wiseman, represented Crew, and we thought, these things are affects interpretations of the law, final opinions, they're called OLC opinions, and they ought to not simply be made public when you make a request, but they ought to be made public because 552A1 says they should be made public affirmatively in advance. So we went to court and sued, and they said, well, no. The first thing you said, the APA doesn't apply, even though it's an APA kind of case we're bringing, not an individual records case. Just all you are entitled to do is to figure out what records you want and ask us for it. Well, of course, they don't have an index of their records. So how do you know what they have? How can you possibly ask them for it if you don't know what they've got? We got to the D.C. Circuit, and the D.C. Circuit says, yes, you can get access, but you have to access them one at a time, and you have to figure out what they are. That has been a very slow and unsuccessful process so far. The one case that really been litigated on the merits was a case in which the court found that it wasn't an opinion, it was just a recommendation. And while one can debate that, there are many cases in which this is what you may do and this is what you may not do. And so we haven't been able to get those through. The Administrative Conference in the United States, in which I'm a senior fellow, had a project in which government access to all government required to make public affirmatively, and this was the recommendation, all legal materials, the kind that the IRS has been making available and many other agencies, affirmatively on your website. So the reporters for the project said, well, that ought to include LLC as well. I said it ought to include LLC. Don't know what happened, but somewhere along the line, the decision was made, no, OLC is different. And it's going to be much more problematic to try to get this recommendation through. And the OLC part was removed from the recommendation. Meanwhile, there have been litigations going on to get even the indexes so you could start to make the FOIA request. And the DOJ has been fighting this. They're fighting it. Some parts of the indexes are still considered to be Exemption 5 material, and other parts are considered to be Exemption 6 because they have the names of senior attorneys at OLC as having authored parts of the recommendation. And so we're back where we started from with OLC. Back in the old days, we would have gone to Congress and said, Congress, you have a stake in this. Not only are they abusing the laws that you have, but you should want to know, and it should not be partisan because OLC has been doing this on behalf of the executive for Democrats and Republicans off and on for decades. There was some noise made a couple of years ago about it, but not very much has happened. But I think it's time for the next great project to go after these OLC records. These are formal opinions. These are not just somebody picks up the phone and says, what do we do today? These are formal written opinions. They get signed. They get put in a binder. They have all the indicia of the formality that there could be. And the OLC says, no, this is really not what you want to have. So they need a champion. I hope we can identify somebody up on the Hill who really wants to make this their goal, and all of us in the access industry ought to be doing that. Thanks for indulging me, and I look forward to the rest of the day. I have some things that I have to do here at the school, but I'll be around most of the day. Thank you again.
Thank you, Alan. Lauren, did you want to? You look like you want to chime in here.
I thought that was fascinating, and I'm so glad that you brought up OLC opinions because it's not just a public access issue, as you alluded to, with members of the public trying to obtain that information through FOIA. It's also a congressional oversight issue. There have been individual members of Congress, at least, who've tried sporadically to win the release of this information, and they haven't gotten it. And I think that points to the issue of federal agencies not just stonewalling members of the public, but also members of Congress, oftentimes using the deliberative process exemption and things like that. So we're dealing not just with the public not having access, but Congress as well.
Great. Would anybody like to ask a question of Lauren or Alan before we get to the next stuff? Anybody? Yes, Miriam Nisbet.
Hi, thank you. That's so fascinating, everything you said, and I have I've taken a lot of notes, but I'd like to go back to the overclassification issue, and which has been around for a long time. It's been around a long time. We've had so many recommendations on what could be done, the problems. We go back to Senator Moynihan, who did extensive championing on this. Is there anybody on the Hill who cares about this issue? Because it is due for a big overhaul.
Let me repeat the question for the camera recording, but Miriam Nisbet, former OGIS director, asked, is there any interest on the Hill to deal with overclassification?
I'm happy to take a stab at that. I mean, you mentioned Moynihan, and the last time, a congressional committee really looked at this was the 90s, 97, and the Moynihan Commission pointed out problems that we still have, 30 years later. But the answer is yes. I do think there are two committees in particular that are interested in overclassification. One is the Homeland Security Committee in the Senate. They came out with, I thought, a really interesting bill earlier this year called the Classification Transparency Reform Act, something along those lines. I might be butchering it. But it had some really smart ideas in there, I think, including punitive measures against agency officials who continually and willfully overclassify information. Also, one of the things with overclassification, we have no idea how much it costs. We have no idea how many documents are actually classified. And so one of the things this bill suggested was agencies coming up with an overall classification budget, which would help get an idea of the size of the program, and also dedicating at least 10%, kind of the declassification tax, 10% of that budget to declassification efforts. And there are a couple other good ideas in there too. I think that was the bill that also suggested getting rid of the confidential classification category. It's a good bill, not going anywhere, unfortunately, but that committee is interested in it. The other committee that's been looking at it as the Senate Intelligence Committee, this is something that Ron Wyden has cared about for a long time. And he has been trying to get something called the Sensible Classification Act passed for a couple of years. Iterations of it were passed, I believe, last year. And the one that was passed that with just brief components of it recently was not so, didn't have much of a change. But one of the ideas that he wants to get passed is having basically an executive agent on classification to be in charge of classification across the government. The way it was proposed in that bill initially was having the Director of National Intelligence be that agent. Current rumblings is that it should be someone at OMB. Think of that what you will. But so yes, there are at least two committees, but the efforts to get bipartisan support is difficult.
Go ahead, Alan.
I was going to say, if you're talking about what to do and how you can do overclassification on even a document-by-document or group basis, my sense is that the federal judges do not want to be in that business. They don't. They're very reluctant to say when somebody comes in with gold all over their cap and all over their sleeve and say this is highly classified. Judges don't want to be in the business of second guessing them. They have too many other things they have to do and too much else going on. So I think if we're going to deal with the overclassification, not future and trying to get terms how long classification should last, we probably need some kind of a independent executive agency made up of people who have prior experience in the military and the State Department to on a authorized basis, that's where you take your classification disputes to them with no judicial review. And the idea would be kind of an interim effect. The government that you're going against essentially your peers, people who have seen classifications over the years, and the idea would be they would be judging, and cause efforts to get the federal judiciary to do it on any. I mean, it does work a little bit, but only a little bit. And I think we got to think about trying something else.
It sounds like ICECAP, which handles MDR reviews over at the National Archives. I mean, it's a wonderful system. It overturns agency classification decisions something like 75% of the time, but ICECAP is housed at the Information Security Oversight Office, which you're familiar with, which is tasked with not only staffing in ICECAP, but also the Public Interest Declassification Board and a number of government projects that have government-wide importance, but ISU itself is probably understaffed, probably needs more people. So you could talk about elevating ISU or replicating something like ISU perhaps outside of the National Archives. But yeah, it's a good model. It's an effective model.
But you have to have people whom the classification community will respect.
And ICECAP has representatives from CIA, state, justice. And
better to have people who are retired.
Well, that's a good question, and put a pin in that. Let's loop back to that at perhaps the last panel with the future, and because you also raise a good point. Is there interest on the Hill for transparency? And we should talk about that because that's going to be important. And what interest will there be next year, depending on what happens with the election? So that's a great topic to talk about later today. Thank you. So let me wrap up this panel with looping back to the big picture here, why we're here. And I understand probably everybody in this room drank the Kool-Aid, right? I mean, I'm looking around the room and I see folks who understand the importance of FOIA and government transparency in general. So I'm don't think I need to preach to the choir, but I think it is important to set the stage, particularly for the recording and for students and others, of why this is important and the growing body of research that shows exactly how this affects every person's life. I mean, this isn't just some abstract democracy thing. It actually matters, and there's more and more social science showing why. Of course, we know it leads to a better journalism. We have research that shows about a quarter of news stories rely on some basis of public records or public meetings. Government, these laws matter in getting this information to the public, particularly at the local level, just covering city council. And that all stems from FOIA to a great extent. And we'll hear more from our next panel of journalism types talking about that. Just dozens and dozens of examples. In fact, if you're interested, there's a lot of lists of journalism stories that couldn't have been done without FOIA. Rick Bloom, some of you may remember, he was from Sunshine and Government Initiative, Reporters Committee for Freedom of the Press. He put together a list of 511 stories that were produced through federal FOIA. He called it the FOIA Files. You can find it online through the Internet Archive because that's no longer around. Toby McIntosh, a few weeks ago, posted a list of examples of this success out there. There's a guy in British Columbia, Stanley Tromp. He's cataloged more than 2,000 stories just in the province of British Columbia that were reliant on their public record laws, which is based on FOIA. And then Muck Rock and we at Breckner, our newsletters, we provide examples every month about the good that comes from FOIA. So that's one thing. In fact, there's an economist from Stanford, James Hamilton, who did a study and found that for every dollar spent on public records-based journalism, society benefits $287. That's a huge return on investment. We're talking saved lives. We're talking more efficient government, lower taxes even. And studies have shown over and over the benefits that having open government makes government more efficient. The jury's a little out on reducing corruption. There's some studies that show it helps on that, others. So we're still arguing over that in the academy. But there is substantial data showing it leads to cleaner drinking water. It leads to safer restaurants. It leads to school choice, the ability for parents to pick and choose the schools they want their kids to go to. One study showed it increases credibility and public confidence in government. In the one case, the Social Security Administration. So it actually helps government. It greases our economic machine. Look at all the data information provider companies out there that rely on government data for businesses to conduct business. Some studies show up to 2/3 of FOIA requests submitted by commercial interests. So it matters. One study analyzed FOIA requests in general and found roughly 2/3 have some public benefit, direct benefit, not just some abstract thing or out to just help an individual. We know FOIA helps historians, thanks to National Security Archive and others who unearth amazing records of our past that we can learn what happened after the fact. So hopefully maybe we could not repeat those errors in the future is the goal, right? We know that FOIA has changed attitudes in this country. Remember after the Iraq War got going and soldiers were coming home from Iraq in coffins draped by flags, and journalists all around the country were trying to get those photos of the dead soldiers coming home, and the military did not want that out. So a bunch of people submitted FOIA requests, were denied, and there was this gadfly from Tucson, Russ Kick. I don't know if you recall, he created Memory Hole, where he gathered records through FOIA and put them online just on the side as an active citizen, much like the government attic with Michael Revnitsky. He was denied as well. But unlike the journalists who stopped, unfortunately, at the time, he submitted an administrative appeal, and they gave them to him. They sent him a CD with these photos, and he put them on his website, and all of a sudden all the journalists were asking for him so they could put them on the nightly news and in their papers, which they did. And of course, those images can affect public attitudes. We saw that with Vietnam. And so, FOIA can make a difference with whether public supports a war. In 1980, OIP issued a report. I found this, I thought it was funny. They were asked to do a cost-benefit report on FOIA. What's the pros, what's the cons of it? And of course, they start with the cons, the expense and the hassle, and as of course, Antonin Scalia was famous for saying after the 74 amendments were passed, he argued in a piece, it's the Taj Mahal of the doctrine of unanticipated consequences, the Sistine Chapel of cost-benefit analysis ignored. He particularly didn't like the attorney fees in the 74 amendments, saying that if an agency denies a Freedom of Information request, shazam! The full force of the third branch of the government is summoned to the wrong party's assistance. So, there. He was. And so, as a result, OIP did this report, kind of some of it mimicking what he said, but they acknowledged the benefits. And in fact, they said, you know what? We found that forcing agencies to look at what records they have and create indexes and retention schedules, they're actually getting their records in order, and it saved and reduced storage costs. In other words, they were getting better at destroying records, but that was seen as a benefit to agencies. And the indexes that were required in the 74 amendments helped train new employees about agency activities. So they would say, this is what we do as an agency. See the records we produce, what we do. So there were these, unanticipated benefits of FOIA and the 74 amendments that has helped government, and no doubt continues today. Finally, I'd like to say that FOIA, even the weak 1966 version before the 74 amendments, has served a role model for the world, right? This is reverberated across the planet. Now, we had states with public record laws long before FOIA, including in the 1800s. So the concept of a public records law was not new with FOIA. In fact, I'm working on something, but I sensed FOIA was patterned a little bit after the Louisiana state public records law, and which is kind of weird, huh? If Louisiana was the role model for the world in FOIA, but now 140 countries have FOIA laws. 140, that's phenomenal, and they've adopted much stronger laws than we have in the U.S. In the last 20 years, the countries they've learned from our mistakes, right? And in the right to information ratings online, you could see our FOIA law ranks 78th in the world out of 140 countries. We're in the bottom half now. And that's simply because these other countries have figured out how to do it better. I liken it to FOIA being like this classic 1966 Ford Mustang. What a great American car. It's just so cool. And but you know what? If you buy a 2024 Elantra, or I don't know, you're going to have better AC, safety, performance, sound, reliability than that 66 Mustang. They've learned from, our research and trial and error over the past coming up on 60 years. I have to do the math. I don't know. I was a journalist. So yeah, we are going to gripe a lot today about FOIA and the problems that it still has, and hopefully we'll talk about solutions, and we'll talk about the importance of the 74 amendments. It was a significant step and improvement in the law, and then the subsequent amendments since. And we have a lot more to go, but it's made a difference, right? This has made the world demonstrably better, and we should always keep that in mind. And because typically we're nattering nabobs of negativity, right? Most everybody in this room probably nattering all the time, myself included. And we should also remember the good that comes from this and all of your work and your interest in this. So the fact you're even listening shows that we have people who care. All right, so we have 10 minutes, and I'd like to open up questions. I see Mr. Tom Sussman with his hand up. Let's start it off, Tom. Should I do the Donahue thing with the mic, if it works?
It's a short question. David, you had said that the literature was not particularly convincing on the relationship between transparency and anti-corruption. Can you elaborate on that? Because obviously that is the justification being used often now for urging transparency in developing countries.
I mentioned that the jury's out on whether FOIA and transparency laws reduce corruption. It's like a lot of research and the law, it depends, and it's complicated, right? So there's some studies that indicate, yeah, it reduces corruption. I think it does. I mean, we see it anecdotally, particularly with journalism. I mean, every journalist who covers government is trying to find out how money is being misspent, public officials doing the wrong thing, exposing that. That's what they do. And I used to do that, and so I saw it firsthand that it kept government honest, and therefore I think reduced corruption. The difficulty has been quantifying that. So like they'll have a study where they'll measure people's perception of corruption. And it actually goes up after FOIA laws are passed in other countries. So the perception is corruption goes up after FOIA is passed. Well, no, that's only because journalists are now able to get information to show there's corruption. So now the public sees, oh, there's more corruption. So it's complicated. I tend to favor the studies that indicate that FOIA roots out corruption. But to be honest, academically, I also have to acknowledge there's a research that challenges that. So around the world, anyway. But I believe it does.
Right.
For a counter take a little bit.
Sure.
I mean, corruption obviously takes a lot of different forms, but I think of the Pentagon Papers, leaked by Daniel Ellsberg, and how that shaped public opinion on the U.S. and Vietnam. However, the Afghanistan papers that were published by the Post showed that a lot of similar trends continued decades later. So I think one of the issues when we're talking about, whether it's corruption or misdeeds, FOIA takes a long time to change, both legislatively, but also to continue to see that those changes are actually taking place in agencies. And I think that takes ongoing public attention, and that is a difficult thing to muster because it is, in some ways, FOIA is a nitty-gritty thing. The way agencies behave can be arcane, and it can be hard to sustain public interest in that. So I'm a little bit more skeptical, but that's just me.
That's a good point. I think it's completely fair. We should be skeptical.
All right, we have a question over here.
Yes, Mr. Jason R. Barron from the University of Maryland.
Thanks, David, and great remarks here. President Obama initiated the Open Government Partnership, and in the last decade, there's been a movement in open data and open government. Beth Novak, who is a brilliant scholar out of NYU and Yale, had a provocative article in the Yale Journal about 10 years ago saying, "Is open data the death of FOIA?" And she said that as open data's scope continues to expand and its culture becomes a comfortable part of government agencies' behavior, policymakers have to reevaluate the role of FOIA. So could the panel talk about the enduring value of FOIA in light of the open government movement?
It's a great question. One of you like to start?
I mean, that's a very thoughtful question. And I think, the death of FOIA were to result from agencies publishing actually open data. In some ways that would be a victory of sorts, but we're not seeing agencies do that and be in full compliance with the Open Data Act. So I don't think that we're going to see the death of FOIA, just like I don't think we're going to see full compliance with the Open Data Act. And I think it points to one of the biggest problems that I saw when I briefly worked with an agency was that a lot of agencies still aren't that familiar with the records that they have, much less how to get access to them, whether it's the records management official or the FOIA official, to do anything with that data, either in response to the Open Data Act or to the FOIA. I think a lot of the problems that we see with data and records has to do with what's happening at the beginning of a document's life cycle. And I think that rather than dealing with it at the end of a document's life cycle, and I think as we're looking forward to how to improve FOIA going forward, hopefully reduce classification, I think we have to think more long-term, especially now that these documents are mostly electronic, how to build eventual public access in at the front end. So I think the fact that we're still dealing with it on the back end hinders us.
So have agencies now changed all their answers from no to yes, or it's already published? No. The death knell is not likely to occur anytime soon.
Yeah, absolutely. I mean, in government, at all levels of government, they post great data sets and other information online proactively, and we need more of that. But there's always going to be a need for FOIA because there's information they don't want to put online. And that's the information typically the journalists and NGOs and others are trying to get. And that's why we need some kind of recourse ability for people either to sue or some other alternative enforcement mechanism in addition to judicial, recourse.
Well,
I think FOIA is always going to be needed.
But there are things certainly outside the bounds of FOIA, and some agencies do proactively post a lot of data online. But depending, what happens with the political administration, good efforts, for example, at the Consumer Finance Protection Bureau could be completely undone. I think a good example of data that was published not as a result of FOIA, but that was a public good was the ToxNet map, where you could go and you could Google put in your zip code and see what kind of environmental concerns there were in your area, and that was taken down. That wasn't something that was a result of FOIA, but it was an open data decision or a closed data decision. So I think one of the questions is, what do you do with these sometimes norms and sometimes laws that some agencies do a good job and other agencies don't do a good job, and there's no enforcement mechanism for the ones that are doing a poor job, even if it's the law to do so.
Definitely. Remember 2016, records at the EPA website were disappearing? Yeah, good point. Thank you, Jason. Got another question over here.
If I could offer a dissenting opinion, or probably a concurring opinion, obviously transparency is terribly important for journalism, and the next step is the public seeing what the journalists say. But my experience also indicated that there is an awful lot of benefit to individuals who just find out about their own records about themselves or records about a question that just generally affects them. And there's no way in the world that it would ever make a newspaper. But I found that there was a lot of benefit to individuals with, at justice, and I don't mean just the prisoner who wants to say, who was the snitch who got me in here, but people learning about the system.
And to the extent that FOIA releases can capture public imagination about things that we're all interested in anyway, FOIA won the release of the CIA's first official confirmation of Area 51. People like hearing about that stuff, and it gets them interested in something that is in some ways more serious than the cultural significance of the release.
Absolutely.
After working with the FOIA for over 35 years, serving as a prostitute for the government, the overwhelming share of that time. I made the first request on my own this last year, just for curiosity. I'm a retired military. I go to the commissary at Walter Reed. There was a sign up, closed temporarily for safety reasons. Oops. That was all it said. And it had been up there now, I'm going out, holy cow, it's been up there for 2 months. What could this be? And there was no place to find out. So I wrote to the commissary system, and lo and behold, I found out there had been a sinkhole underneath the commissary, and cracks were in the walls. They had pictures of the cracks in the walls. I got from the photographs. I saw where the floor was sinking in the commissary. This was just safety reasons. And I did something that I had rarely found to myself. I called the FOIA officer and I said, when I worked at Justice, we used to encourage this sort of thing to be made proactively available to people. They could have said a lot more on that sign and on their website where they said safety issues. And he says, you're certainly right, but that's above my pay grade.
Oh, that's outstanding.
He can talk to people above his pay grade.
Well, and we do know, Margaret Kwoka from Ohio State has done a lot of research on who submits FOIA requests, and by and large, journalists are just a smidgen of the total requests, anywhere from 1 to 10%, depending on the agency and study, whereas average people constitute far more, using FOIA every day in their state public record laws. So, yeah, this is critical for the average person. I myself use it personally for when I go to buy a house. I'm always checking out everything around the neighborhood, the sellers, the neighbors. Because the realtor's not going to tell you if there's a problem, but we can find out that way. And I even requested through the Privacy Act in 1974 my FBI file, which I have one. So,
Congratulations.
I don't think most people do, but these uses are so important, and this is so important for everybody. We definitely need to make that clear. Thank you.
I'd like to thank Dave, Lauren, and Alan for jumping on this first panel. That was a great conversation. I hope you all enjoyed it. We'll take now a 15-minute break or so, and we'll reconvene if you could be here slightly before 11 o'clock, and we have our media panel starting then. So thank you again. As we get settled for the next panel now, I don't want to delay us any longer. I just want to, again, very quickly, if I may, thank the co-sponsors who have helped make the event a success today, and in particular, GW Law. This is a great space when we have all of our FOIA experts or judges today. The Breckner Freedom of Information Project, University of Florida College of Journalism and Communications, and then also Essential Information and the Center for Responsive Law, POGO, and National Security Archive. All these groups have helped make today's event possible. And so far, I think it's been a great conversation. So let's keep going here with our panel on media and transparency.
Sure. Thanks, Ryan. So I'm going to coordinate, not moderate this, with my two great co-panelists, Katie and Charlie. But I'll kick this off by bringing out one of my prized volumes, the House report on the 74 amendments. I am looking for the Senate edition still, so if someone has that tucked away, send it my way. As a lot of people here know, but maybe not everyone, the 74 amendments were vetoed by the president, the power at B, and Congress overrode the veto. So in the spirit of hearkening back to Congress telling the executive branch and agencies, no, release more stuff, I'm going to read a little bit from Ford's veto letter. And also to show that the same battles that were going on in 74 are still going on today. Talking about records, specifically law enforcement, but that any person could go to court unless the government could prove, quote, separately for each paragraph of each document that disclosure, quote, underlined, would cause a type of harm specified. So still battle today is if the documents aren't going to harm anything, why not just release them? Most of my friends in the media would say release them. Some of my friends in government would just say, well, if the exemption says we can technically withhold, we're withholding. And then the last point that President Ford disagreed with me on was we do not have the personnel that would needed to make such a line-by-line examination of information of requests that involve sometimes hundreds of thousands of documents within the time constraints of the current bill. And I think many of my friends in government would agree and say, yes, yes, yes. But the good news for the requesters is that battle is over, and due to the 74 amendments, we and our lawyers point out in court that you do indeed have to go line by line of every document and segregate all releasable material. So I just wanted to say this in the spirit that the president did not like more openness in 74, and the people that did won. So I hope that in the future, maybe in the coming years, that'll happen again. So after my historical digression, I would like Katie and Charlie to introduce themselves. Katie's from Reporters Committee. Charlie's from Brand X. I'm in the New York Times. I'm from the Washington Post. And why don't you talk about how you got into FOIA, which is the Freedom of Information Act, I think we all know, and use that as a way to introduce what you do today.
Hi, everyone. I'm Katie Townsend. I'm the Deputy Executive Director and Legal Director at the Reporters Committee for Freedom of the Press. It's a nonprofit, national nonprofit, but one based here in Washington, D.C. that provides legal services to journalists and news organizations. So I am the token lawyer on this panel. I'm a media attorney, and I represent journalists, news organizations, as well as the Reporters Committee itself in federal Freedom of Information Act litigation and other matters. I got into FOIA actually when I started at the Reporters Committee. I came to RCFP as a media and First Amendment attorney out of private practice, and we found there was significant need for FOIA help among the journalism community, not necessarily folks at newspapers like the New York Times and Washington Post, where there are journalists and resources with deep knowledge and experience with FOIA, but for a lot of freelance independent journalists, folks that are newer to the craft, they often need help navigating the FOIA system, figuring out how to use FOIA to fuel their reporting, and also dealing with the inevitable, which we will talk about, barriers to actually getting FOIA to work for them, which often requires going to court. And I think more frequently requires going to court. So that's how I've got into FOIA. It was about 10 years ago that I started at the Reporters Committee. We have a ton of FOIA resources that I also really should mention for people who are not aware of it. They're free, they're open to the public, they're on our website. They include things like the FOIA Wiki, which is a resource that was developed in consultation with and cooperation with a bunch of other great organizations, but was really spearheaded by my brilliant Reporters Committee attorney colleague, Adam Marshall, and it is a fantastic resource for FOIA, all things FOIA. With that, I will turn it over to Charlie.
Thanks. So yeah, I'm Charlie Savage. I work for the New York Times. I've been there since 2008. And when so working at the Times is a great, obviously, lucky place to be. And one of the ways it is lucky is that it has a lot of legal resources available to reporters to bring FOIA litigation. So there's a newsroom lawyer named David McCraw, and every year we have a First Amendment fellow, which is essentially like a judicial clerkship for someone coming out of law school. And they basically just David does some defense of, when someone's trying to subpoena a reporter, but a huge amount of what they do all day is litigate FOIA for us. And as everyone knows, FOIA is both a beautiful law and a dysfunctional law, and one of the ways it's dysfunctional is you basically have to go to court to get anything in something remotely a timely fashion. So if you're someone who's interested in your own FBI file, maybe you can wait 3 years and it's still interesting to you. But if you're a reporter wanting to know something that's of current news value waiting 2 or 3 years for them to get around to processing your request is pointless. You've got to do the 20-day working days and go to court. And for that, you need legal resources. I, as a legal policy reporter, and someone who was interested in executive power and specifically interested in the history of Dick Cheney. When I came in the mid-aughts, I was writing a book about the Bush administration's expansion of executive power and the formative experiences that Dick Cheney had in the Nixon and Ford administration when there was sort of a collapse of the imperial presidency because of Watergate and the Church Committee and the Vietnam War, leading to the environment in which Congress was briefly functional, and the 1974 FOIA amendments, the first bill that was passed by Congress after Ford took over when Nixon resigned, which Nixon then vetoed on Anthony Scalia's advice and Congress overrode, as we just heard, was very much in the forefront of my consciousness. And I started filing a lot of FOIA requests, and I was kind of looking around, and partially that was because I had lawyers who were willing to pursue them for me, but I was also looking around and realizing really in that era, which was like 15 years ago now, there were not a lot of mainstream media reporters that were making use of this tool. There was basically Jason Leopold, who was kind of bouncing around BuzzFeed, CNN, various other places, one of the great FOIA warriors of our time, Jason. And then there was me, and I was bringing maybe 6 cases a year, and like no one else was doing it at all. There was a couple years went awry when the Washington Post filed 0 FOIA lawsuits, and it's which makes no sense, right? And it's like this tool was sitting gathering dust, and I think that because of the controversies of the 21st century, a lot of which have to do with secrecy and leaks and so forth. There's been growing awareness over the last 15 years that FOIA is something that should be a routine part of the arsenal of reporters, and a lot of people have woken up to it over time, and now it's, left and right, there's interesting lawsuits happening and documents being liberated as a result. Maybe less often than I would like, but way more than was happening in the mid-2000s. So I've been glad to see the crowd arriving, and with that, that's how I got into FOIA.
Cool.
Well, I have to add one thing to Charlie's biography, which is very, very important, which is he is a member of the Reporters Committee Steering Committee, so I would be remiss if I did not mention
Bias. Pro reporter.
Thanks to both of you. So I got into FOIA due to a slightly rude archivist. I was in undergrad, and I was researching this thing called Able Archer 83, which in a sentence is a little bit similar to the Cuban Missile Crisis that happened in 1983. It was a very realistic nuclear war drill that NATO conducted, and the Soviets as allies reacted and readied their nukes. And in Western intelligence, it said, "What's going on? This is scary." Got all the way up to Reagan and Thatcher, and tensions cooled, but it was a nuclear flare. So I was researching this in the Reagan Presidential Archive, and how it works is you do the finding aid, and you see what the boxes of military war games. Okay, get that. And there's a folder that says Able Archer 83. You pull it out, and then you open it up, and it says withheld, classified, and your heart sinks. I traveled as a student. I paid my own way there. It wasn't online either. So I asked the archivist, I said, "Oh, is there anything I can do?" And he could say, "You can try FOIA, but that'll never work." So instead of giving up, I got kind of angry and started looking it up, and ended up at, like Lauren, my colleague, said earlier, ended up at the National Security Archive just right over there. Again, anyone interested in FOIA, anyone interested in documents, anyone interested in fighting government secrecy at GW, go over to National Security Archive at the top of Gilman Library. I came to GW because they were here, got an internship here, was there for about 12 years, I think, before finally the Washington Post said, you do a really good job filing requests for historic secrets and tracking those, appealing those, and sometimes suing for those. Why don't you come over to the Post and try your hand doing that for day-to-day secrets? So I've been there for about 5 years. I'm the FOIA director there. Help litigate, help requesters file requests, track requests. Basically, if a reporter gets a denial or has an idea, I brainstorm with them. And then I also write a column called Revealing Records, so shameless plug. So that's who I am. So I think what we're going to do now is just I'm going to ask a few questions. If you have questions, think about them. If you have So let's go. Why don't we tell the audience? I mean, we talked kind of a bit about like the grand theories of FOIA and the right to information, but what is it like to be in the trenches, sometimes battling, sometimes working with government information specialists to get documents released? Katie or Charlie, will you tell us about a current or recent FOIA win, FOIA battle, and just how it works? Like if someone in the audience has never filed a FOIA or went to court, what's it like? Spill the tea.
All right. I can think of a couple of different. This is cheating, I guess. A couple of different battles that I'll touch on, and the reason I think of two is that when we are thinking about impact in the FOIA litigation space, the Reporters Committee, we're thinking about it in two ways. We're thinking about it as impact litigators. How can we improve the law? How can we improve the legal landscape for all journalists? That's our constituency. And so we're looking at litigation that way. We're also looking at it from candidly a journalistic perspective. Is there information here that we can help this reporter get that's going to make really a meaningful difference in terms of their reporting and possibly lead to really impactful, really incredible reporting? So I can mention a couple of ongoing cases that we're litigating at the Reporters Committee on behalf of now colleague of Charlie's at the New York Times, Azmat Khan. When she came to us originally, she was a freelance reporter, and she was reporting on the sort of true human cost of the U.S.-led U.S.-led coalition drone warfare in Iraq, Afghanistan, and the Middle East. And what she was trying to do was to identify instances of reported civilian casualties from drone strikes in these regions and go in these areas, and then go and report on these. So when she came to the Reporters Committee, she had FOIA requests to the Department of Defense with specific casualty or drone strike incidents, dealing with hundreds of events, and she needed help. She was getting no response from those requests. So we filed lawsuits. We have two cases on behalf of Azmat that are currently ongoing. But what I think is interesting about this is when I think of legal impact or litigation impact, we've actually not briefed anything in that case. She had no responses to her FOIA requests at the time we filed suit in the Southern District of New York. As is typical of FOIA litigation, I think folks will speak to this, because there was no determination, we didn't need to administratively appeal, we went straight into litigation. At that point is when the responsive agencies started actually processing records in response to her request. We had a very experienced, and I would say very good, assistant U.S. attorney on the other side representing the agencies, who was very much willing to work with us and our client in terms of identifying priorities for processing, because there were so many different instances, and we could negotiate, okay, well, we'd like this first, and maybe we can forego these types of documents if we can get these types of documents, that kind of horse trading that can really benefit clients, especially if they're like Azmat, incredible reporters, and they know exactly what they need and when they need it. She was able to use those records that she obtained for the civilian casualty files, which was a series of front page stories, incredible reporting, front page in the New York Times, for which she then won a Pulitzer Prize, and the Times won a Pulitzer Prize in international reporting. So I highly recommend taking a look at that reporting. I think of it as a huge victory and a way. I always point to it as an example of the way that FOIA really can be an incredibly powerful tool for journalism. And I like to emphasize, this didn't require litigation, really. It required litigation to get the agency to process records. And to be clear, we will fight about redactions and withholdings later on, but we haven't even gotten to that point yet. All of that reporting was based on what was actually initially released and is still being initially released by the Department of Defense and its various components. So that's one ongoing battle. I can come back to the other ones.
I'm going to use my prerogative and interject. So I've heard kind of a lot, actually. People say, well, wait a minute. You're just suing to cut the line. How come it's okay that someone can file a lawsuit and cut the line with people that either choose to wait patiently or don't have the resources?
Yeah, and I've heard that objection before. I would say a couple things to that. To a point that Charlie made earlier about whether there are cases, and I will say we don't litigate. The Reporters Committee makes its own FOIA requests, and frankly doesn't litigate all of those FOIA requests. And we don't agree to represent journalists in every single FOIA case. But journalists, and Dave made this point earlier, actually make up a pretty small percentage of overall FOIA requesters and FOIA requests within the system. And oftentimes you're dealing with information that it is a public good. It's not just an individual good, but it's a public good to have access to sooner rather than later. And so to me, I think if I'm looking at it I can understand the argument of, well, I made the request for my own FBI file, and I've been waiting a long time for that. I understand that, but there's information that the journalists are attempting to get to fuel their reporting that will benefit everyone. And that is really one of the most fundamental purposes of FOIA and the entire statutory scheme.
Thanks.
So I'll build off of what Katie was saying in terms of like how does the process work in reality, and then I'll also tell a story about something I'm working on. I think that in the previous panel we heard about how no judge has ever actually ruled that exemption 1 was not met because something was not properly classified, but just the fact that the judge has that authority in the abstract exerts a disciplining force on the bureaucracy. They don't want to take a weak case to the judge and risk having that first precedent, and so they put out more information just because of that enhancement in 1974. And so it's not quite working like you might think on paper, but it actually has a meaningful substance to it. And I think FOIA is quite similar to that in other ways. In my experience, it's exceedingly rare for a judge to order a document released over the objections of an agency. It has happened, and like for example, I in the Times won a case to get most of the Office of Legal Counsel memo about the targeted killing of an American citizen and whether that was lawful. It was put together in the early Obama administration out when the Second Circuit ordered it out. But that was the exception, not the rule. There was a whole twisting and turning, idiosyncratic story for why they ruled that way when most of the time courts don't rule that way. But what happens in practice is, first of all, you file your request, it goes to the back of the line, they're not going to process it until 5 years from now when they get to it, if you wait. So you wait 20 days and you file the lawsuit, and now it's at the front of the line, and now there's an AUSA whose job it is to deal with the headache of this litigation. The AUSA wants to dispose of this litigation and becomes actually your advocate inside the executive branch of what can we do. And the horse trading that Katie was talking about is a huge part of the process. You apply for all documents about X, and they come back and they say, we couldn't possibly even begin to assemble all documents about X. And you said, well, what I really want is this. And you narrow the request as part of the negotiation, and then they can live with that, but it's face-saving for the agency as well, because you're not getting all documents about X anymore. You're just getting memos written between March and April by this particular bureaucrat about X or something. Without any further litigation, you agree to settle the case for that narrowed request. That's how it happens most of the time when you succeed, and there doesn't have to be a judicial ruling. Maybe if you're in the classified world, you might try to challenge some redactions, and then suddenly you get to briefings, but it's rare. So that's the real world process, but it requires going to court and to trigger it and jumping the line, absolutely jumping the line. So what? I agree with the why of the so what, because I'm doing something in the public interest, I'm not just a commercial vendor who's assembling information about some patents, and I'm not just an idiosyncratic individual interested in my file. I'm looking for something that millions of people might potentially be interested in. So a current case I'm working on that's of particular interest, this will take a minute to tell, but it's of an interesting story to root this in something more granular than a lot of the abstract language we've been talking about. You may recall that there was a torture program in the early Bush administration that run by the CIA that was initially secret, initially came out, and that at the end of the Bush administration and then spreading into the beginning of the Obama administration, there was in multiple investigations into that torture program, starting with Bush inquiry, the destruction of videotapes of torture sessions by the CIA, and then expanding to all things related to this program where laws broken when the Obama administration took over in 2009. Separately, the Senate Intelligence Committee conducted its own investigation. But the fact that there was this Justice Department investigation run by John Durham, then an assistant prosecutor out of Connecticut, later perhaps more famous as the guy the Trump people hoped would uncover a deep state conspiracy about Russia, the Russia investigation, and who famously failed to do so after 4 years at the end of his career. But John Durham was running this investigation, interviewing CIA agents and witnesses, and because there was criminal risk for people involved in the program, they would not cooperate with the Senate investigation. They used that as an excuse not to let the Senate staffers interview people who were involved, Fifth Amendment rights. And then when the Senate investigation report comes out, the deep state, John Durham's later foe, is able to discredit their report because they didn't even talk to any witnesses. They didn't ask for the other side. It was purely based on CIA documents. And so there was an attempt to discredit the Senate report, which is the best public history we have of that program, as incomplete and maybe mistaken because they didn't really look under every rock, and because John Durham would not share with them his investigation reports and his witness interview reports. So in 2012, I filed with the New York Times a FOIA lawsuit in New York for the reports that Durham had submitted to Attorney General Eric Holder, which resulted in no one being charged for that program, and the FBI interview reports called FD 302 reports of all the witnesses, saying this could be a supplement to the Senate and the public understanding of this important history. We litigated for a couple of years. A judge ruled for us initially on the reports Durham had sent to Holder, because when Holder announced that no one was going to be charged, he said, John Durham has looked at this and I've read his reports and I've decided we're not going to charge anyone, or he's recommended against charging anyone. And so our argument was he's adopted this as official policy. This is no longer pre-decisional, and therefore you have to put it out. And a judge in New York agreed. The government went up to the Second Circuit, and the Second Circuit said it wasn't specific enough. Holder didn't say, this is my, I'm not, he didn't utter the magic phrase, I'm adopting this. And so they sent it back, and after a couple more years, we basically got a few lines of one report where Holder had been specific enough to use the magic phrase. It was just like some names of detainees who were never in CIA custody, so you couldn't really do anything with that. But then things changed. The Senate declassified, or the government declassified the Senate's 500-page summary of its report. More things about that program were declassified because of Guantanamo military commissions. Our thing had lost on Exemption 5. We never got to Exemption 1, but it was still sort of a sign that information was in the wild about this thing now. And then, of course, as everyone in this room knows, Congress amended the FOIA Exemption 5 in 2016 to say you couldn't just have blanket boilerplate. This kind of thing would be harmful if it came out. You have to show specific reasons why this specific thing would cause harm. And then there was a very good D.C. Circuit opinion in a case led by the Reporters Committee that interpreted that in a way that was very favorable to requesters. And so we said, let's take another bite at this apple. It's rare. Usually once you lose a case, you can't come back and take another bite of that apple. We tried. So we brought it in D.C., not in New York. I recruited a retired colleague of mine who's no longer with the New York Times to be a second identical requester with a separate legal representation. So if they tried to kick us out by saying the New York Times had litigated this already, we could say, well, this guy is not the New York Times, and he wants it too, which they did try to do, and that worked. And we cited this changes to FOIA, the changes to the law, the changes to the facts in terms of what had been public. And we got as far as the judge here, Judge Boasberg, recently looked at the Durham reports to Holder in camera and then ruled against us, said that it's still that the government's showing was enough, that this kind of thing was there's nothing of this could be made public. But he didn't say that as to the FBI witness interview report. So we're still litigating over that. And so this case, in addition to just its historical interest in terms of national security, legal policy, and torture, and the war on terror, and what will ever be known or not or buried about that program, is also of interest as sort of a test case on what is the meaning. We were still trying to, despite this very good DC Circuit opinion that they won, what is the meaning of having to show specific harm? They were making the argument that it's future oriented. So like, why would it be harmful for this special investigation report produced 10 years ago? Why would that be harmful in the future for this information to come out? We're not talking about the classified information in it. We're just talking about the report itself. They're making the argument, well, it will cause special investigators like Durham to self-censor the next time they're doing a high-profile investigation into something of public interest, and not, chill the candor of their internal writings on are they going to charge this guy or not? Why? What do they find about him? What's the weaknesses of the case, et cetera? And we were saying these special investigation reports come out all the time now. There's the Mueller report, there's the Robert Hur report, there's Durham's own report on Russia stuff. Like when people know when they're leading one of these high-profile investigations, that because it's high profile, it's very likely to come out. And we didn't really get a clear answer on that because but it led to Boasberg at least looking at the stuff in camera, which the judge in New York had not done, which I guess is a symbolic victory, if not a great one. So anyway, that's something current that's ongoing.
Can I jump in and talk about foreseeable harm? Okay, I can't resist. The case that Charlie mentioned, the DC Circuit case, is actually the case I was going to mention as an example of what we think of when we think about litigation impact, because the idea being, and this was the foreseeable harm, I think most people in this room know, the foreseeable harm provision was added to the Act as part of the 2016 FOIA amendments, and it precludes agencies from withholding records, even exempt records, subject to discretionary exemptions, not Exemption 3, but exempt records if they can't demonstrate that they reasonably foresee that the harm tied to the exemption would flow from disclosure. So the Reporters Committee did litigate the Reporters Committee and Associated Press case against the FBI, which is sort of the leading case in the DC Circuit to explicate kind of what an agency must show to demonstrate that it's complied with the foreseeable harm requirement. And so I wanted to kind of use that as an example, and I wanted to also let people know that even though the Reporters Committee case did arise in the Exemption 5 context, it was a deliberative process privilege Exemption 5 set of withholdings that we challenged in the DC Circuit solely on foreseeable harm grounds that led to that ruling. And there was some hesitancy, or we saw some, I would say maybe just uncertainty among district courts kind of following that decision about application of foreseeable harm to other discretionary exemptions, including exemptions like Exemption 7E that kind of have sort of a harm concept built into it. Courts were like, I don't know how to fit these two things together. Maybe they don't apply at all. In fact, we got an Exemption 7E ruling that's sort of like, foreseeable harm doesn't do any work in the Exemption 7E context.
Which is law enforcement.
Yeah, law enforcement techniques, and sorry, I'm just assuming everybody knows. But what I wanted to note is there was a really recent DC Circuit decision in a Jason Leopold case. There are many Jason Leopold cases, but this one was an Exemption 8 case. And I would note that the DC Circuit sort of clarified in that case that the foreseeable harm provision applies to all exemptions except Exemption 3, which Exemption 3, as you know, incorporate or may not know, incorporates kind of other statutes that require withholding. And so that was a really
300 of them.
Yeah, but that was a really nice clarification because I think it makes clear that the very great ruling that we got in RCFP AP against FBI on interpreting what the foreseeable harm requirement does and what it requires is not limited to.
But what's still in play is just like how specific does it have to be?
Yeah,
and that's where you still got to fight every time.
I think that's right.
I'm going to work in a couple of practical tips. And I take the point that a lot of times, and I have to be the bearer of bad news to my colleagues at the Post, if you want a document from the Department of State in time to make the newspaper in a conceivable time, you're going to have to sue. But I also have this chart that I show them that has, it looks like this. It kind of goes, ooh, and the top quarter is maybe about 10 agencies that have average processing times that are very long, 5 years longer. But once you get past those bad 15, we might call them, there are about 100 plus agencies that have processing times that we know because they have to be annually reported because the 74 amendments now require that. That we know now the data that shows that their processing time, 75% of government agencies, is close to less than 20 days. So if you're fishing where people aren't fishing, you can get the documents quickly. If you need an FBI document, State Department document, a lot of DoD documents, you're probably going to have to sue. Justice, which is supposed to encourage compliance with FOIA, you're going to have to sue. But on the bright side, there are a lot of agencies that will process your documents within the timeline. Additionally, most states, I know we're talking about federal FOIA, most states are much quicker than federal FOIA. So we get lots of documents about the border from states where CBP is slow and states are fast. That's a practical tip. I want to talk about one more thing that Charlie brought up called the deliberative process privilege, which might be every requester's least favorite privilege. It's under Exemption 5. I've heard it called the withhold it because you want to privilege. And I just want to note that I was double checking. I was reading the 74 amendments and the 86 amendments and the 2002 amendments. And in all of those, I think I got the numbers right, it never says the word deliberative process once. The first time the word deliberative process came into statute was the 2016 amendments, like we're talking about. And then it was a phrase under Exemption 5 that says deliberative process shall not be used for documents older than 25 years. So I just want to mention that the requesters' most hated exemption, deliberative 5's deliberative process, which is used, so essentially it's, in my opinion, it's so vague that agencies can use it to withhold anything, especially if it's something embarrassing. That's what they use. It was created by the courts, and the only time it's been in statute is when Congress said, whoa, we got to rein this in. Use this only for 25 years. This leads into my next question, which is going to be, if you can give advice to Congress for one thing they should change about FOIA, what should it be? My advice, very quickly, would be just cut off 3 words. Just say, under Exemption 5, which incorporates privileges used in discovery and other methods, except that deliberative process shall not be used for documents older than 25 years, delete the last 4 words. Deliberative process privilege shall not be used. Period.
Should I go? Do you want to go first? Okay. So I actually always struggle with this question. I get asked it quite a bit. And one of the reasons I struggle with it is because if you just look at the plain text of FOIA, it's actually fantastic. I mean, it's really fantastic for requesters. It has tight timelines. It has tight timeframes. It provides for de novo review by a court of withholdings. I think the to your point about the 2016 amendments, you know, the overuse of the deliberative process privilege it's very clear from the legislative history. One of the things that pushed Congress to not only put in the sunset provision, but also to enact the foreseeable harm provision. I mean, it was one of the arguments we made as amici of Machado Amatis, which was the first DC Circuit case to interpret foreseeable harm, and then also again in the AP case, was that this is the exemption that Congress intended to apply to all discretionary exemptions, but this is really the one it was real worried about. So I think actually, if you said to me, what do you think Congress could do? So that's a very long way of saying, I think that it's not about the statutory language so much as it is the implementation, both by agencies and by courts, right? The significant delays that are contrary to the statutory language are, I think, the biggest problem with FOIA. And so if you said to me, what can Congress do? Don't make it an unfunded mandate. Provide some funding for agencies. You kind of put your money where your mouth is when it comes to the importance of transparency. And I think the resource allocation would probably make the biggest impact when we talk about whether FOIA is dysfunctional or whether it is functional.
Yeah, hiring more FOIA processing officers is a great answer. just to build off of this deliberative thing, or to answer your question as well, and hearkening back to the previous panel, that my number one banging my head against the wall for over a decade has been OLC opinions, Office of Legal Counsel opinions, the chunk of the Justice Department that sets the legal parameters within which the executive branch can operate. It is functionally a final policy. You can do this and you can go no further. But they have taken the position, therefore it should not be pre-decisional deliberative. But they have taken the position, no, because the decision maker can always choose to ignore the lawyer who says you will not go to prison if you do this, but you will go to prison if you do that, and do it anyway, so it's still before the decision is made about whether to do the illegal thing, so you can't have it. Of interest with the 25-year rule that now exists, which of course retroactively it confirms there is a solid one for 24 years and 364 days, is that the Knight First Amendment Institute at Columbia University has a very interesting FOIA case, massive FOIA case for old OLC opinions that are older than 25 years, and has just been getting out a deluge of paper. And it's a historical interest, right? It's like, well, what were they yelling about in 1967? And there's things in there about the civil rights movement and about the Vietnam War and Cold War and stuff. And there's also just all random stuff about fights that, political fights that are long since forgotten.
And can't impeach the president, right?
Yes, there's the, there were certainly things of interest in 1974 that have been of interest, newly of interest in the Trump era of renewed interest. So there's, and they've gotten a giant index of these historical opinions, and then they've, in the same way that you have to kind of narrow it to make it realistic, they picked the first, I think, 100 or something, that just based on the titles of these things that they're interested in seeing. So a place to look for stuff that's old, but of course what really matters is what's contemporary. And that's what they just won't give it out.
Thanks. So I hope you're thinking of questions. I hope we were provocative enough to maybe bubble some up. Does anyone have any questions from the audience? Yeah, Michael Bell.
Yeah, hey, I think I can project, and it's more a comment than a question, going back to the deliberative process privilege. As a FOIA officer, it's actually my least favorite as well, because as I said, it's vague. When I'm reviewing redactions, I want black or white, release, withhold. And then when you get in the gray areas, that makes our jobs harder. So my opinion is, I do not like it as well. I would much rather have yes or no on release or withhold. So just want to say, it's hard on us as well.
Thank you. Appreciate that.
When it's gray, you should release.
Dick Huff, and then in the back. Yeah.
I would like to dissent from that. I was the appeal authority, not during the 2016, but going back, even though there was some earlier, the one with the foreseeable harm or demonstrable harm under Janet Reno. And I still have scars from my back where her high heels hit me in the back saying, disclose more. She pushed that hard, and that was something that seemed to be easy to me. There was one point where we were telling the FBI, you had to be very little, don't withhold a lot of information under the second clause of Exemption 7D. That is, not only protect informants, yes, do that, but sometimes information that was provided by an informant would not disclose who that informant was and could be then otherwise disclosed. And I remember one case where the FBI said, no, that's just, you can't do that, that would be wrong. If that informant is killed and shot in the face, it's going to be on your head. And I said, I could handle it. But, you know, it was an easy judgment there, not a close call. Second thing I'd like to mention to Charlie is you might consider mentioning, or you, all three of you, it can make a heck of a difference where you bring your lawsuit. I'd say generally my experience is the District of Columbia judges understand the law. They may not always rule with you, but they're not going to rule against you because they don't understand the law. And that will happen in many places. probably Charlie's jurisdiction, I suspect you've got fairly knowledgeable Southern District of New York judges there. That used to be the case, and I assume there is. I don't know if there's any other jurisdiction that is particularly knowledgeable. Maybe Northern District of California. I'm not sure about that anymore.
Yeah.
Thanks, Dick. Yeah.
Maybe just a couple of responses there. So one, just to jump back on foreseeable harm for a minute, I think, one of the other things I could have said in terms of what would you recommend Congress do? Actually, my colleague Adam Marshall and I both proposed, kind of somewhat controversially, the addition of a public interest balancing test to FOIA's discretionary exemptions, which I still stick by. And the reason for that, and I think that would be a great addition to FOIA, is because I think when Congress enacted the foreseeable harm provision, it was in fact a codification of existing internal policy at DOJ, but it was intended to be more than just a codification. But it really puts the onus on the agencies. In other words, it's not and unfortunately, I think a lot of the work that the foreseeable harm provision doesn't happen until litigation, if that makes sense. In other words, I think that agencies are not really applying the foreseeable harm provision, and I think the way that we as requesters would hope, and also I think the way that Congress intended to get the foreseeable harm provision doing work at the administrative level, not just once you get to litigation, you're arguing about, hey, actually this shouldn't be withheld under foreseeable harm. I think public interest balancing would do that work more at the judicial level, and I see those two things working hand in hand if Congress ever enacts that provision. But I think foreseeable harm, I would love to see do more work at the administrative stage. On the jurisdictional point, DDC is obviously the place you can bring any FOIA case. It's universal jurisdiction for FOIA cases. There's a lot of FOIA work that's done in SDNY because of the New York Times and others. And so they also, to your point, you're exactly right. You have judges who are quite experienced with FOIA, know the act quite well. I don't know that benefits you, and that sets aside, by the way, jurisdictional precedential differences, because there are different legal precedents in New York in the Second Circuit than there are on the DC Circuit, and depending on your case, that might influence where if you have the choice of filing in the Second Circuit or the DC Circuit, which one you sort of choose. But even setting those aside, I think sometimes I worry. We've coined the term in my office FOIA fatigue among DDC judges. They get so many FOIA cases that they maybe it doesn't get the same amount of focus and attention that you might get in a jurisdiction where they don't quite see as many FOIA cases because there are just so many of them. And they tend to go right into a sort of processing schedule. And so I think that while I take your point about the expertise, and that can be incredibly beneficial in many FOIA cases, we often think pretty carefully about where we want to bring FOIA cases. We don't always default to DDC.
Following up on that, you also have to worry when you're bringing one in Nebraska or somewhere, and I don't mean to pick up on them particularly, but what kind of an AUSA you're going to get. Mm-hmm. Because there are rare cases that we had seen in justice, and I'm sure it still happens, where we look at a case and somebody will say, how the Sam heck did you win that? Why did you ever take that position? And the answer is, we didn't. An AUSA was talked into it by an agency in Nebraska. Mm-hmm. And that's the sort of case that if the government wins, if an appeal were ever taken, the SG would say, we're not going to defend that case. Mm-hmm. That's the rare sort of thing that would happen. But it does happen in some of those cases, and I think it is quite rare for that to ever happen in D.C., for the SG to ever say, I'm not going to defend that, because the AUSAs are the assistant United States attorneys that defend the cases are a bit more considerably more knowledgeable. This isn't the first case they've ever handled, as it is in Omaha.
Thanks, Dick. I think we had a question in the back earlier. Yep.
Earlier, you guys were talking about litigation as though that's the only way to get a response. But you mentioned narrow the scope, right? And you were talking about in litigation how there's negotiation going on in which the scope is narrow. My comment is, why don't you do that in the initial stage? Why wait until litigation for that to happen?
Thanks for asking that. I actually was going to tell a war story. I'm not going to do it because we don't have time, and my point of the story was to be specific and to narrow. In my call of revealing records, I did an illustrated guide saying how to request a FOIA, like a comic, and the big one had me waving a fishing rod saying no fishing expeditions. So at the Washington Post, I go around town saying narrow, narrow, narrow. A practical tip is replication. Don't reinvent the wheel. If you go on muckrock.com, that has, I think, more than 10,000 FOIA requests that you can see. You see one that's successful, just tweak the language a little bit so that you can get that exact record. And thank you for that question, because I go around the newsroom saying, narrow that, no fishing expeditions, put yourself in the chair of a FOIA processor. If you don't know where to look, they're not going to know where to look. Mark Walker, great FOIA guy in the New York Times, says, treat your FOIA request like you treat a news article and do your research first before you click submit. So thank you for that question. And I agree that the best FOIA requests are narrowly tailored, very specific FOIA requests.
Well, I would just add, if I could just add to that, though, I mean, absolutely. And one of the things that I try to do, very often the Times and the ACLU we're similar cases, and we end up as co-litigants. They tend to do the fishing expedition stuff, and I tend to do I want the memo that was written on May 14th by David Barron, and they want all documents related to the memo, like emails and stuff. And so then if we either win or lose and drop out of the case, and 5 years later they're still fighting. But why don't you do it ahead of time, separate from the disk? Can I make it easy for them to find it, put their finger on it in the filing cabinet? It won't get processed until you file a lawsuit. You've got 5 years of people in front of you before they even look at it. So you have to get to the lawsuit stage anyway, just so that even if you know it's just this one document and they know exactly where it is, if they look, they won't look, because there's just too many people standing in front of you in line. And so that's where it can actually be strategically helpful to have done the fishing expedition, so you have something to give up.
And sometimes you don't know what you don't know. I mean, we do the same thing in terms of training journalists on how to use FOIA. We talk about making your requests specific, making them make sense, making them understandable, those things that are really important. We had just to give an example that's an obvious one, even at the administrative stage before litigation, we had a client make a request for information related to a company that also happened to have the same name as some kind of government program. And they didn't realize that. So when they came back the administrative stage, they said, well, yeah, you can exclude all the records related to that program. It wasn't that they weren't trying to be specific. They just didn't realize that this other group of documents was going to be brought in by the search terms that they were requesting or the phrasing that they were using. And at the litigation stage, I will say that I find there's something to be said about narrowing, and we often do that. There's also something really good to be said about prioritization. And I think we've had a lot more success, frankly, with AUSAs and agencies counsel and agencies who are willing to consider that kind of prioritization of processing. We'll drop later portions of requests before they get processed if the prioritization kind of gives the clients what they need. The clients are like, well, yeah, let's start here. If I get what I need, I don't really know that I need to go much further. That prioritization, rather than narrowing, often works better because it's also more palatable to the journalist. Because if I tell Charlie, yeah, let's start here, and then if we see what we get, maybe we can then narrow the request, he feels a lot more comfortable with that than saying, yeah, I'll narrow it, because then he's stuck with that decision.
Thanks. Tom Sussman.
I'd like to ask a question about media and transparency advocacy, because the FOIA was enacted in '66 because of the effort of the communications media industry. 74 amendments. The veto was overridden because of the advocacy, the lobbying by radio, television news directors, the SNE, National Newspaper Association, et cetera, et cetera. And, and to the extent there was outside foundation funding, that also went to groups that were doing advocacy. Now, the foundations have gone either local or to universities that do litigation. There's no one in the media world picking up on all of these suggestions that are being made about how to improve the Freedom of Information Act. So, I think that it's it's unlikely that there's going to be much progress made unless members of Congress can see that someone out there besides Washington public interest groups care.
I'll take a first crack and then I want to hear what you say. Advocacy has been a little bit controversial in my newspaper the past couple of weeks. And even before that, advocacy of any type was controversial. So I agree. I don't like it because I care about Freedom of Information Act. I remember being interviewed for the job and they acted like it was a huge favor to me. They said, you can, Nate, advocate that it's good to release more documents. Thank God, or else I couldn't do my job. But that was a big departure because newspapers today are so focused on not advocating. I will mention that so I agree that's a big problem. I would love to see the press advocate much stronger to improve the law. And there's all these state laws, and we're always playing defense. And there are special interests that are passing law after law after law at the federal level to make more close government and the state level. We do work with the Reporters Committee a lot, but there's a feeling, just in general, in my opinion, that we're not going to play that. We'll let Reporters Committee do that for us, and they are awesome. But I agree it's not enough. I'd like to see newspapers advocate for improved access to information laws as strongly as they advocate for protection of journalists, and as strongly as they advocate for general First Amendment. They're okay advocating for that, but for some reason they do get a little cold feet for access to information laws. I agree. I don't like it.
And I think I would just say too, I mean, unfortunately, the news media both has struggled, I think, from an economic standpoint, right, in the last decade to 2 decades. But they've also, I don't think it's a secret to say that news organizations aren't the most popular people in the room. And so, I mean, I take your point, Tom. I think the way that we as an organization that does advocate for FOIA reform and works closely with other transparency groups to do that, I think one of the things that we think about is actually more of a big tent approach than relying so heavily on media advocacy, because we're not sure that's as effective as it used to be. I mean, it was an important part of the 2016 amendments for sure. But another important part of, I think, the next round of FOIA reform, which we hope is soon or within the next 3 to 4 years, I think will be, okay, can we get not just the news media involved in this and not just the other transparency organizations that are also hugely important to that effort, organizations like POGO and others, who aren't strictly kind of media organizations, but fight for transparency. But what about, okay, the immigration lawyers associations? What about other people who are impacted by FOIA delays and by problems with the law? Can we get everybody together to work on these issues? Because I think just the way that the political arena is now, that just the news media's voice, I think, is quieter because there's fewer resources, but I also just think it's maybe less persuasive than it might have been before.
Thanks. I saw one over here. Yeah.
Adam Sawyer at Track. Kind of on that topic, we know that a lot of local news outlets and newspapers are under a lot of pressure, and that includes reporters, of course. So I would like for Katie or any of the panelists, could you talk a little bit about, are you seeing that in the capacity for reporters to submit FOIA requests and then sue based on those? Any comment on that?
I mean, absolutely. I mean, that's why the Reporters Committee started a litigation program 10 years ago. It was really driven by the access work, not just FOIA and state public records and open meetings, but also court access to judicial proceedings and records, totally different regime, but another one where members of the news media, newspapers like Press Enterprise, fewer news organizations, exceptions being surrounding me right now, the New York Times and the Washington Post, being able to put resources towards that affirmative access litigation that really benefited the public as a whole and the entire ecosystem. And so I think that's one of the reasons the Reporters Committee has worked hard to kind of step into that void as much as possible, though we're definitely not doing it as much as I wish we could. But a huge amount of our litigation that reason.
And there are law schools that have clinics that help a lot. Yep. I think here has one, and the Media Freedom Information Access at Yale Law School's very active in helping reporters who have a righteous case but don't have legal resources because their employer has been hollowed out.
Great. So thank you for this excellent panel, Charlie, Katie, and Nate. Give them all. So at lunch, we're going to get started with resuming the program. A few housekeeping tips and other announcements. There's plenty of food left over. If you're interested in nibbling on a bit more, feel free to go out there and grab a second box or take one home with you at the end of the day. Secondly, there are speaker bios that we have compiled for all of the panelists today. Those are available. We have printed copies with Claire on the table outside. They're online, and we'll send around a link as well with the post-symposium message that we're going to send to registrants. So if you're interested in learning a bit more about all of our speakers, please take a look at that. Second, I wanted to, there was mention of the Open Government Partnership during the first panel, and I think there has been, if not during the conversations on the stage, in conversations among panelists and participants outside, a mention of the National Action Plan on Open Government. Thank you to the reminder from Daniel Schumann, who's now the inaugural chair of the GSA's Open Government Secretariat Federal Advisory Committee on Open Government. There is a public comment period that closes on the 12th of November. GSA is collecting recommendations for the beginning of the ideation phase for the next National Action Plan, the 6th National Action Plan. So if you have thoughts on FOIA and how that should play into open government or other issues, whether they be record management, open data, anything about transparency in government, please make your voice heard and send your ideas in as a public comment to GSA before the meeting. And as always, both with the FOIA Advisory Committee and with the new Open Government Advisory Committee, you can always, there are mailboxes or online submission forms, I think in the case of the FOIA Committee, where if you have ideas that you want to submit as public comment to the advisory committees, you can do so. And those are read and they are circulated, as I know members of the past members of the FOIA Advisory Committee can attest. We now come to, I think, one of the keynote panel of the day, if you will, which is a fireside chat without the fire between Tom Sussman and Miriam Nisbet about the 74 amendments, a look back and a look forward, I hope, too. I will not introduce them in full because I think their reputations precede them both. But Miriam was the founding, the former director of OGIS at the National Archives, and Tom is at the ABA. Full bios again online and written copies available. So, Tom, Miriam, the floor is yours.
First, as with the earlier panels, we will have a lot of time for questions.
Microphone, mic.
Mic the mic closer.
Got to turn it on too. How about that? Technology. As the earlier panelists indicated, there'll be plenty of time for questions, and we do hope that you will engage. I do want to start by a tribute to Ralph Nader. Brian mentioned him earlier, and Ralph does have a statement out there, but Ralph Nader was really the driving force behind the Freedom of Information Act 74 amendments. He got involved in this area right after the law was initially passed and found it didn't work and came to the Hill for redress. And just, you know, he talks about the obstacles to using the act need to be documented through congressional hearings. Good idea. We need to find a congressional champion these days going forward for FOIA. And he says citizens around the country have to use the act much more. High schools and colleges should teach students about the Freedom of Information Act. And is doing that here. We hope other GW journalism school, communication school, and others will also teach their students about FOIA. And he ends, I hope in celebration of a great civic victory, you'll provide a lighted path forward to further the use of freedom of information laws, which serve as mighty pillars of a resurgent democracy at the federal and state level. So that's pretty moving words, right?
Yes, yes. So, actually, Tom, that might be a good way to talk about how you got involved, how you interacted with Ralph Nader and others, because you really you are definitely a FOIA star, and you've been at this from the very beginning. And maybe you could talk a little bit about how you got involved and also bring in your experience with Ralph.
So I wasn't there at the very beginning. I showed up in Washington in 1968 and went to the Office of Legal Counsel. And by the way, we were giving agencies opinions on compliance with the Freedom of Information Act, not in writing, over the telephone. And I caught Alan Morrison on the phone and said, I didn't realize that he was a lawyer for the U.S. Attorney's Office in the Consumers Union versus Veterans Administration case, because we had advised the Veterans Administration that they had no justification under the new statute to withhold hearing aid test information.
Tom, it's trouble hearing you back. Can you get closer to the mic?
How about that? Better?
Speak right into it.
Sorry. We told them that they had no justification. Read the statute. There's no exemption for what's been requested. And they said basically, pound sand. We were the Justice Department. We thought we were going to be, people would listen to us. They didn't. And they got sued and they lost. But that kind of hooked me on FOIA. That was interesting. It was an important law. I was fascinated with it, but I didn't last long in the Justice Department because there was a change of administrations. And so I went to Capitol Hill, and I was the only young staff lawyer on the Senate Administrative Practice Subcommittee that had jurisdiction over FOIA that had ever heard of it before. And so it was natural that when Ralph Nader came up to the Hill to talk about how this law needed to be reformed and improved, he was sent to talk to me. I had met him before when I was at the Justice Department, but that was our first time together, and I took him over shortly thereafter to talk to Senator Kennedy, who I was working for, and he made a good case for it, and he wrote an article in the Harvard Journal of Legislation called the Freedom from Information Act. And about that time, Congressman Moorhead in the House was holding a series of hearings, documenting all of the problems with the law. And there were many. Costs. You think fees are a problem today? The State Department was charging $12.50 a page for photocopying. Selective Service System was cheaper. It was only $2.50 a page. Okay? Time limits. Time. There were no time limits in the original act. 30 days before agencies would even acknowledge receipt of a request. And then interminable time thereafter. There was no way to get it.
Still not hearing you.
Closer to the mic, Tom.
Well, it's going to have to go up my nose.
Okay, fine.
Okay. One thing after another, it was clear that the law wasn't working. I don't understand why this thing isn't.
That's better.
No.
Up your nose. There you go.
Try the other mic.
Yeah, okay.
And I'll turn the handle over. See if that's better.
Is that better? Oh, it wasn't me.
Sounded like you.
So we decided to start having some hearings on the Senate side. We had a number of, I brought these just to give you an idea of what the legislative history looked like for the 74 amendments. And one of these volumes has background that includes the Moorhead hearings in the House. It includes Ralph Nader's article. And there was a momentum building. I mentioned earlier today the media groups involved in advocacy. And they were on the Hill in strength, in numbers, arguing that the law was absolutely worthless. You think there's a problem now because of time limits for media. At least ultimately you sue, you can get something. Back then, you couldn't get anything. And so all of these factors sort of came together. I confess that the senator I worked for, Senator Kennedy, was busy with immigration, with health care, with a lot of other important judiciary-related issues. But he said, okay, when I suggested that we have hearings on freedom of information. And he went on to chair the hearings, to be floor manager of the bill, chair of the conference committee. Do any of you know what a conference committee is? They don't use them anymore. But it used to be the House and Senate would have different bills, and rather than staff or members getting in a back room and having to agree secretly about what both houses would come up with, we had public discussion, negotiation in a room in the Capitol between House and Senate conferees to hammer out a bill. And we did. And then, of course, there was a veto, and the rest is history. The veto was overridden. The bill became law. The Justice Department had this new act that it needed to look toward the implementation of and involved in litigation. And who better to handle litigation for the Justice Department than Miriam?
Well,
how did you get started?
Not quite, but I do just want to ask one more question about Senator Kennedy, because this was his participation, his offices, his staff, clearly instrumental in moving this along. But was this sort of, his one transparency access issue, or was it part of a broader strategy? I'm just curious about how you got him revved up about this.
Well, it began as a one-off, but he was interested. We had a subcommittee with wide jurisdiction. We did everything from equal employment opportunity to natural gas prices to contract compliance. It was, wide-ranging jurisdiction. And so, in fact, one of the things I pulled out when I was looking for materials to background was an old speech that I'd written for Kennedy to give after the law passed, and he extols him, vaccinator, et cetera. But he then says that he's not done yet, that there are other things that need to be done, and that he has an agenda for that too. The first was
Tommy, you need to fix this mic situation.
We got an IT guy right here. Or AV guy.
I can hear it quite nicely. Is it me or is it the mic?
Now we hear it.
I think it's you, Mike.
It goes in and out.
You got to just stay close to it.
Yeah.
Is this better?
Yes.
Okay. I just used a fresh one. Turn it on green. Okay. Yes? No? This is worse than the other one, isn't it?
Stay close to it.
Stay close. Okay.
There you go.
Is this? Oh, I got to turn it on. It's this white. Microphones don't love me. One of the bills that Senator Kennedy said he was going to introduce, and I was involved in drafting all of these, would compensate public interest interveners in agency proceedings. There was a big movement, and the nonprofit advocacy groups in town were all quite supportive of that. And actually, we got one amendment passed that provided at the FTC for public interest intervention reimbursement. Another bill was lobbying disclosure, which it only took another 20 years before that got some enactment there. And then the third one was whistleblower protection, which was decades before that issue caught fire. We had legislation on all these subjects. But FOIA was the one that we continued. We had oversight hearings at the IRS. We had continued interest in it until we moved on to a different subcommittee.
Good. Well, thank you, and I'm glad it worked out. Well,
Tell us your story.
I'll tell you a little bit, and can everybody hear me okay? Yes. Okay. So I did not arrive at the Justice Department until 1978. And so I was a few years behind the enactment. But I'll tell you a couple of things about that. So one of my bosses was Dick Huff, who's here, and I learned a lot from him real quickly because we had a lot to do. So I joined the Justice Department in 1978 in the Office of Privacy and Information Appeals. And at that time, that office was charged with handling appeals from denials under FOIA for all the agencies within the Department of Justice, which is a lot of agencies. That's about 25 or 30. I don't remember the number at the time. Perhaps our biggest and best known component was the Federal Bureau of Investigation. So that was a lot of work, but within a pretty short amount of time, within a couple of years, our office, and I'm really condensing the history here, so forgive me, Dick, our office was merged with another office and we became the Office of Information and Privacy. And at that point, I think we became sort of the Swiss Army knife of FOIA for the federal government because we were continuing to handle these appeals within the Department of Justice. We also handled requests that came in, initial requests for records of the Attorney General, the Deputy Attorney General, the Associate Attorney General. But we also then, with this new office, moved into government-wide training, government-wide policy, and then a few years later, our office attorneys began litigating FOIA cases that were brought in the District of Columbia, the United States District Court for the District of Columbia. So we had a great, a wide set of responsibilities that sort of gave us insight into FOIA at every level. So in the early days, and I can speak from sort of the late 70s, early 80s, there was still really this, sort of fervor for FOIA. In the wake of Watergate, FOIA was sort of that nervy thing that was happening and that people were afraid, agencies particularly were afraid of, but people were very excited about at the same time. So it was a great time to be working on something that new and different. That also meant, of course, really getting people on board, getting people to understand how it worked and what the roadblocks were, but also the benefits of it. I do want to mention something that I think maybe people other than FOIA and privacy nerds forget, but the Privacy Act that was passed in 1974 was a huge thing as well. And one of the things that we had to figure out at Justice and at other places was not only how to handle this large number of requests coming in, the large number of appeals, because you can imagine there were a lot of denials, so there were a lot of appeals. So figuring out how to process these huge numbers of requests, the huge numbers of appeals, but we also had to figure out how FOIA and the Privacy Act interacted. And that was no small feat because, again, we're talking about something, new laws, new requirements, and in some cases they were, they sort of worked in opposition to each other. So, for example, people were thrilled that they could get access to their own records under the Privacy Act. But if they went to a law enforcement agency like the FBI, there was an exemption in the Privacy Act that basically said, to quote Tom, pound sand. So your rights of access were really now only under FOIA. So we had to figure out, okay, how do these things, how do we take away with one act, but now we're going to give you something with another act, and how is that different if you're a first party than if you're a third party requester? So it was a really interesting and exciting time. Another thing that we had to figure out was, how do we review classified records? How do we set up a mechanism for that? How do we deal with huge volumes of records? So one thing this morning that was mentioned was, for example, the records, the FBI records on the COINTEL program. And that was one of the cases that I worked on as a new attorney in OIP. And we're talking about vast numbers of records that had been withheld in whole or in part. How do you do that in a way that actually is going to get some records released and have everyone, both the FBI and the oversight people in OIP, how do we end up in a good place on this?
So I want to take you back a little bit to the earlier stage where OIP was both defending requests for the Justice Department, defending withholding decisions, and also training agencies to what? To give out information, to abide by the presumption of openness? I mean, is there a tension there?
Sure. Yes, in fact, I remember one time we were having, so we had workshops all the time. We had them in DC, we had them at the Justice Department, we had them at agencies. Sometimes they were government-wide, sometimes they were agency-specific. We had them outside the DC area, wherever people were. And I think Dick and I were probably teaching a workshop on Exemption 7, for example, and talking about, all the different parts and withholding. And I remember somebody raising a hand and saying, all you're talking about is withholding. Isn't the law supposed to be about disclosure? And I thought, well, maybe you didn't get to the morning session. Or we're not emphasizing that enough. And I think we may have adjusted a little bit to make sure that we knew that we were starting everything with the presumption of disclosure. But at that time, particularly early on, we were so focused on what can be withheld. And in addition to the administrative logistics and the process of how you go about handling the requests, keeping track of things, responding to people, what is a good search? At the same time, of course, there are lawsuits going on and there's litigation. And we're trying to keep track of all of those court cases. What do those cases teach us? And in fact, that I think a lot of people here are familiar with the Department of Justice Guide to the FOIA, which started as basically a pamphlet and turned into a tome, because there was a lot of law being developed that it had to inform what we were doing and what we were teaching and how we were going about doing our work.
And I remind you that it was the 74 amendments that required the Justice Department to produce annual reports on litigation so that the U.S. attorneys and public could keep up with what the developments were.
Yeah, and they were really, they felt fast and furious.
Yep. What's next?
Well, maybe because I've mentioned it and it was mentioned this morning several times, maybe you could talk to us a little bit about Exemption 7, because that was one of the more controversial changes in the 74 law. It really opened up law enforcement files, and it gave a lot of people, including President Ford, heartburn. And maybe you could talk about that a little bit.
I'd love to. I do think, as mentioned this morning, Exemption 7 has been a big problem for the FBI, the Justice Department. And it's the initial Freedom of Information Act from 1966 exempted law enforcement files, as was, I think, stated earlier. And that, of course, led to the commingling of exempt and non-exempt into files. It led to the exemption of all FBI records because they said they're all law enforcement files. And the few early court cases, actually, the judges didn't feel that they had the ability to cut through that. When the House bill first came over to the Senate, it did not address the 7th exemption. It addressed the first exemption. I'll get into that later. But the 7th exemption just left as was, and in committee we focused and discussed the subject and wound up proposing a change of the word files to records. Okay, that was it. It went to the committee executive session, and in those days, the Judiciary Committee met behind closed doors. One person on the staff for each of the members who had a bill before the committee. And so I'm sitting next to Senator Kennedy, and an amendment is raised by Senator McClellan, Arkansas. And he has a piece of paper. There's no letterhead on it, but it's typed out what he's reading and saying. He proposes an amendment to change the word files back to records. And clearly an FBI proposal. Because he talked about how this would, destroy law enforcement, the FBI. And he lost that vote. But the other thing he lost was the possibility that the committee could have come out of the markup with some sort of an agreement that would, basically lead the bill to unanimous consent rather than open for amendments on the floor. And so when the bill got to the floor, Senator Phil Hart, whose staff member Harrison Welford was working with us, had the amendment that gave rise to the current 7th exemption. And one of the interesting things about that, and that's, I've got a marker here. Where did that language come from? All right, I'm going to read something from a letter from Elliot Richardson to Senator Kennedy at the end of the hearings, suggesting that
Try her.
well, all right, how about, is this better? No, I don't know what's going on here. Maybe it's my voice.
Try this.
This mic? Is this, I like this one. Yeah, okay, this is good.
Hold on to it.
So I'm going to read what Elliot Richardson proposed. The provisions of this section shall not be applicable to matters that are ... 7. Investigatory files compiled for law enforcement purposes except to the extent available by law to a party other than agency, provided that with respect to, etc. And then it goes on to interfere with law enforcement functions, deprive a person of a fair right to fair trial, partial adjudication. You get the thrust. That's the language that Senator Hart then modified somewhat as his floor amendment to the 7th exemption. And that was adopted by the Senate. So that also led to just apoplexy on the part of the FBI. And they made it known to the White House. And during the process of during the conference committee's deliberations, the presidency changed. And President Ford was under tremendous pressure to try to get the bill changed and modified substantially before it went to final vote, because he knew that the Senate and House would likely approve whatever came out of committee. And so, there were a lot of discussion. That was the seventh exemption and sanctions and B1 on allowing the courts to review classified information in camera were the three lightning rods of the 74 amendments. Ultimately, the FBI came to us. We had some discussions, and one of the memos that I got under the Freedom of Information Act, nodding because the National Security Archive posted all of these, and by the way, they're going to put them back up online on the 20th or 21st, which is the actual anniversary of the 74 amendments. But I had, a number of conversations with the FBI, and it was clear that I wasn't going to be able to agree with what they wanted. There can be no doubt that he, Sussman, and others of like mind will oppose any move which will give the FBI any meaningful relief. There is, of course, tremendous overtones of pure politics involved in this matter. Okay? The liberal Democrats would be pleased to force the president to veto this legislation since they see it as a big campaign issue. I confess that was not what the staff's perspective was. I'm not sure what the members were doing, but I don't think so. I think that was the administration trying to politicize it so that they would get a veto. Can I move into the veto issue?
Yeah, and that was in 74 that was written.
This memo was June 7th, 1974.
Okay.
And earlier today, I think there were some comments about using the FOIA for personal purposes. I believe Dick mentioned that, not just for media and high visibility, but use it for yourself. I got just stacks of really good stuff out of the FBI and the Justice Department by asking for information about me. So this was quite fun reading all of this. When it came to the veto, other Justice Department memos say we don't really want to improve the legislation in conference now because, quote, we want it to be as bad as possible so that the president will veto it.
Oh.
Okay? And I guess it was because the president did veto it. And the quarterback of the administration, of the agencies, trying to persuade the president to veto it because President Ford had been a congressman. His instinct wasn't anti-freedom of information. His initial instinct was to sign the bill, to try to work with Congress. But the FBI and CIA strongly wanted him to oppose. But a little-known lawyer, head of the Office of Legal Counsel, named Antonin Scalia, was involved in organizing the agencies to make clear to the White House that it was a matter of life and death to the agencies that the president veto the bill. And he did. And there was, these guys were pretty smart because Vince Rakestraw, who was the Justice Department's Congressional Affairs officer, said the House is going to override the veto. There's no issue about that. And there wasn't. And that was due in large part to just a media blitz of the House at the local newspaper editorials supporting overriding the amendment. The Senate was going to be a lot closer. And the media worked very hard and continuously in the Senate as well. But when it came to a vote, there was basically an override. It's 2/3 of those present and voting. An override that 2 votes made the difference. But it actually was 1 vote. Because, inside story, Senator Scott, the minority leader, later told Senator Kennedy prepared to override, to sustain the veto if his vote made a difference. But since there was already 1 vote difference, he decided not to, that he would go with the majority. So that was, and probably the most exciting and frightening time of my time on the Hill was during the Senate roll call vote on the veto override.
Wow. Well, I have sort of two observations on that. One, things, there's swings. Swing this way, swing that way. And some of you may remember that in 1986, there were further amendments to FOIA, and a big part of that had to do with Exemption 7. The Attorney General at the time was Edwin Meese, and he wrote in a foreword to the AG's memorandum on FOIA in December 1987. In the wake of the Watergate affair, Congress decided to alter the course of government disclosure policy through a series of, quote, liberalizing FOIA amendments. Fits right into what you're saying. The most significant of which restructured and considerably narrowed Exemption 7, the Act's vital law enforcement exemption. But in its reaction to the perceived need for greater disclosure, Congress overcorrected through those FOIA amendments and seriously impaired the ability of federal law enforcement agencies to perform their crucial mission of protecting our citizenry. So you can see that the fight did not end with the passage, but it took a while, but what came around, went around, came around.
So there was another section of the amendments that the president singled out as being very pernicious, and that is sanctions. Because this was a Nader initiative that government employees involved in FOIA should be personally responsible for arbitrary and capricious withholding. And so the bill coming out of the Senate committee had empowered the courts to order sanctions for individual government employees responsible for withholding. That was one area that, with the president's objection, we did make some changes, requiring the court only to refer this to the Civil Service Commission at the time, and then the government would take whatever action it wanted to, which of course was unlikely to do anything. Now, was that worth the paper it was written on? It is often said that the sanctions have never been imposed, and therefore were worthless. And I don't think so, for two reasons. One is the training that Miriam talked about the Justice Department engaging in the late 70s, I think in large part was responsive to the feeling that we needed to educate our employees on how to apply this law. I mean, I don't think they were educated on how to do other things quite as much as the FOIA staff on FOIA, so that no one wanted to be the first to be sanctioned. I also think that gave rise to the birth of ASAP, because the American Society of Access Professionals was a result of government employees in the access world feeling that they needed more than just the Justice Department training. And so ASAP was born as a voluntary organization that provided the opportunity for FOIA officials to make sure that they wouldn't be the first to be singled out as having been arbitrary and capriciously involved in withholding and referred for sanctions. So even though the law has, and I once did a study of sanctions in other countries, and a lot of them have sanctions. Some of them have monetary penalties for officials who withhold information unreasonably. Most of them are not used. In fact, I think India was a case where there were so many rubles you could be fined, but they never were. The fine was imposed, but they weren't collected. And so I think that there seemed to be, to me, in the end, a similarity across the board that, having them in the law is useful. And in fact, Ralph Nader, in his letter, in his statement, mentions the sanctions need to be increased. And I think that they've served their purpose now. And what we need to increase is resources for the people who are in the trenches.
Absolutely. In fact, if we, want to talk a little bit about future amendments, I'd like to talk a little bit about the ones that have already happened. But resources have always been a huge problem. Everyone that knows anything about the world of FOIA will agree that it is an easy and good example of unfunded mandates. Every agency must respond. Some of them have huge responsibilities because of the breadth of their departments and agencies and the kinds of records they have and the sensitivity of their records. And the resources have never been there, and it would make a huge difference.
So here's a question for you. Should there be line item appropriations for FOIA activities in the agencies? I mean, we went back, the President Ford, after the veto was overridden, went back to Congress and said, okay, you've done it to us, you've shoved it to us, now give us funding for our FOIA offices to be able to comply with this new law. And Congress didn't. And then there was a debate over the next few years, should there be budget line item funds for FOIA? And I mean, the debate is still going on now because there is some concern that it really puts it in the hands of Congress to, if we don't trust that Congress will do something, then the agencies will all be able to say, sorry, we're closing down our FOIA offices. Congress didn't appropriate anything this year. Or we have twice as many requests this year as we have last year, and we have less funding. And so therefore, Judge so-and-so, you can't hold us responsible for not responding within 3 years. And so that's I've been back and forth on that debate for 50 years now, and I don't know what the answer is.
I don't either, but we're now at over 1 million requests a year. So definitely people are using it. Definitely people want access to information. And in my experience, the people in the departments and agencies who are handling this really would like to do a good job, but it's pretty overwhelming.
So you talk about the litigation that you were involved with. How do the agencies respond to the time limits? I mean, we did for the first time, and of course, as everyone knows, Congress has adjusted the time limits. 10 days, 10 days for initial response, 20 days on appeal. You may ask, where did we come up with that?
Yeah, where did we come up with that?
Random. It could have been 20 and 50. I mean, there was no magic number. Obviously, no agency said, oh, we can do it in this time. Some of the agencies were doing it in meeting the deadlines from the start. And there still doesn't seem to be a magic number. But was that a problem when you first got involved with advising agencies and litigating?
Sure, it's still a problem. I mean, I'm not directly involved in it now, but not so much in the litigation that I had, but it's definitely still an issue, even though we have a little bit longer time now. But I think there need to be some other solutions for this. So one of the things that I heard this morning in the second panel, you have to sue You have to sue to be able to, get anybody to pay attention to your request. And, we just wait for the time limits to pass and then we sue. Well, a big change that was made in the 2007 amendments and again in the 2016 amendments, of course, has to do with the Office of Government Information Services, OGIS, the FOIA ombuds. And a big impetus for that was the idea that we would have some alternatives to litigation. And that would be mediation and the variety of techniques that fall under dispute resolution. It seemed to me that one of the cases, for example, that Katie Townsend this morning was talking about, that ended up in a lawsuit in the Southern District of New York, and she talked about the really terrific assistant U.S. attorney that was handling the case and how he had really helped them work through all the aspects of the request in terms of, exactly what was being asked for and finding out where the records were. That is precisely the kind of thing that OGIS is, designed for. Again, that's another instance of a really good idea that is working really well and at the same time is definitely under-resourced because, of course, the FOIA Ombudsman has as its client base all the departments and agencies and all the public. So that's a pretty wide group of people to be acting for. I'd like to see it used more and for it to have more resources.
Well, of course, our alma mater, the Department of Justice, was not exactly a constructive participant in the development of a FOIA ombudsman. The Administrative Conference had a study in the mid-'80s, I think, for alternatives to litigation for FOIA, and came up with a few alternatives: Ombuds Office, administrative appeals to a central panel. Justice Department organized agencies well. In the Administrative Conference, half of the members of the conference are from government, and I was a member at the time strongly supporting a recommendation for an independent agency, and it was defeated because of the Justice Department. And then, of course, when OGIS was initially enacted, the legislation first came into effect, the Justice Department Office of Information tried to get its budget and powers transferred to the Justice Department. And fortunately, Senator Leahy, who was the Judiciary Committee proponent of the establishment of the office, also happened to chair the Appropriations Committee at the time. And so he told the Justice Department to pound sand. And there was nothing they could do because he appropriated funds for OGIS. And
was a very, very strong supporter.
Right. And, I think, and on that, I do want to, we're going to take questions, and we need to get you guys involved, but I do want to spend a few minutes, just as Alan Morrison sort of mentioned, David Burnham this morning. When we started planning this program, I thought, well, this is great. Let me try to see how many others I can wind up from the 74 amendments battle to come and join us, and we can have maybe 4 or 5, 6 people across the panel. And Miriam, of course, wasn't there at the creation, but she's close. That's good. You had to defend our hard work. Because, it was 50 years ago. Okay, so fine.
Okay, are you trying to say we're the only people alive that are alive?
I learned there's some others alive, but I couldn't find them, or they've retired, or they're not answering their phone, or whatever it is. I mentioned the Hart Amendment on law enforcement, and that was Harrison Welford was involved as staff person. Muskies did the first exemption, and that was Jim Davidson was his staff person there. On the House side, they started the process with oversight hearings and drafted the first bill, and that was Bill Phillips and Jim Cronfeld. The lobbyists who were involved, and they were everywhere. There really was effective lobbying work by media organizations. I mentioned a bunch of them this morning, but also the Nader organization, Ron Plesser, Mark Lynch, Ralph himself, Joan Claybrook, ACLU, John Shattuck, Consumers Union, Peter Schuck, even the American Bar Association. I was glad to see it was on the side of good and not evil. John Miller testifying strongly supporting the amendments. And then the media associations. So it was a really, I like to say that I was in the middle of it, and my boss, Senator Kennedy, was really at the head of the column. But nothing would have happened without all of these people. And it's just, I'm really quite sorry that we wasn't able to get hold of any of them to show up today. But that put teeth into the law. And really, I think, made it workable, with all of its problems, but workable for the first time.
Yeah, let's see if we can get some questions here, or comments. Doesn't have to be a question.
Don't be too enthusiastic.
Stories.
There we go. Yes, sir.
You all talked about a few other enforcement mechanisms outside the courts in the executive branch. I know there have been a lot of talk about adding more enforcement mechanisms inside the executive branch. What would that look like? What do you feel about that?
Other enforcement mechanisms. So if we were to put, if I could paraphrase, if we could now put some additional enforcement mechanisms in place, what could that look like?
The best would be to empower an independent office like OJIS, like they have in Connecticut, Mexico, with the authority to make a final decision. You still go to court if they support the agency, because judicial review is really sort of the bedrock for all the final stop for all important disputes in the federal system. But we've got to get away from having to go from the agency to court. And I think that enforcement mechanism, that having an independent adjudication that would be not a litigation, not a court, but a decisional commission that could overrule an agency and require. Now, maybe not for national security, without some sort of a system that was discussed this morning.
Yeah, I thought that was a really interesting idea.
With the former national security people making the decision, and maybe even not for law enforcement. And one of the reasons I say that's practical, because I think probably the law enforcement agencies would be more amenable to that kind of a change if they had some special approach as well. But that still leaves an awful lot of requests that are denied that could be resolved short of litigation, because most people would give up before litigation.
But again, having greater resources for an ombuds office, alternatives to litigation, could go a long way. I think it could work.
Thanks very much. In 1974 and even today, did you see a conflict in having the same department, the Department of Justice, that defends agencies' withholdings, and a lot of them, in objective opinion, I think are bad withholdings, also house the Office of Information Policy, Office of Information and Privacy, that is supposed to encourage compliance. So on the one hand, in the same department, to restate my question, you have the person that's supposed to be the FOIA watchdog, and in the same department, you have the people that are defending the agencies when they violate FOIA again and again and again.
Could I respond to that, Nate?
Well, I'll ask Tom, and then Tom and Miriam, and then I'll let you go.
respond first. I would start by saying that some of it is personalities, that I don't think the current head of the office in the Justice Department is quite as defensive of agency withholding as previous ones. But a lot of the times I also think it blows with the wind. That is to say, administrations come and go, attorneys general come and go, and that office is going to, can't offend the attorney general. And so, if an attorney general comes in who's protective of information and wants to hold his or her job under the president, and there's not going to be a lot of encouraging, especially if information could be embarrassing or consequential to the administration. So, yeah, that's a problem, and that's why I think that when OGIS was first created, the head of OIP professed herself to be the government's ombudsman on FOIA, and there was a. Were you involved with that? I think you were. The question of who would attend the International Ombudsman's Conference. Mm-hmm. Miriam won.
When Miriam was in OIP, she knew, as I did, it is not a Class B felony to disregard advice of the Office of Information and Privacy. We can tell you, Department of Defense, that is not something that you can withhold. That's wrong. Or we could say there's no harm, either one. But it's not covered by the exemption. Go to hell, Justice. You then get sued, and you're sued in Omaha. Is that AUSA in Omaha going to defend you? Yes.
How often they tell agencies not to let stuff go? OIP.
It was not uncommon that we usually didn't see it at the litigation stage, but people would ask us our advice on how can we withhold this, and some of the time the answer came back, you can't. I mean, being honest, in many cases, we would say, yes, here is the exemption, here's how it works, and here are 3 cases. But in some cases, we say, there is no case that permits you to withhold that, and I don't think that it's an acceptable area to try to build new law.
Well, that's what the Reno Memorandum was all about, was to try to get the Justice Department not to defend agencies. Yeah. And that didn't work so well.
Right.
You're correct.
But, going back just to the general premise, certainly the Attorney General has a responsibility to enforce the law. And the law is about disclosure. And if you start from that helps. But, as Tom says, not all AGs are created the same. It's a bit of a problem, but as Tom said, that potential conflict, Nate, in the case of the Ombuds Office, I think was settled in exactly the right place, and that was to put the ombuds at the National Archives and Records Administration, which is the only agency in the entire government that has as its mission to make information available. And so I think it was a nice fit.
I mean, the other answer to the enforcement question is we made a lot of changes in the 74 Amendment, which opened the door to litigation to enforce the law. The attorney's fees provision, the D.C. Circuit, that discussion from this morning is allowing all cases to be brought in the D.C. Circuit. Actually giving priority to cases in the court. That was later eliminated, but we gave priority in court cases to FOIA cases. So we saw the benefits of having a independent judicial adjudication being the last word, and so tried to facilitate that as much as possible. So all of the litigators can thank me for that.
You want to take one more question?
Okay. You've talked about oversight from OIP and from OGIS. What about OMB? In the 80s, they had some oversight responsibility. How did that work out, and do they still have any role in it today?
Well, the oversight of the Privacy Act is now firmly at OMB, which it was not before. So I would say, as a practical matter, the division of labor is still DOJ for FOIA, OMB for privacy.
OMB could be a force.
Yes, could be.
And in fact, most recently, let's see, the first Freedom of Information Advisory Committee, 10 years ago, recommended that OMB update and revise the fee schedule for FOIA cases, for FOIA requests. And it did a half-bottomed job. Some of us since then have been trying to get them to finish the job. Here from OMB. You're excused. You can go back and rewrite the rest of the fee schedule.
All right, so let's take the panel here.
Thank you.
All right, we'll get started. Before and I'm a panelist here too, even though I'm in the I don't know, is this the witness box? I don't know, or the stenographer's box. I guess it'd be normally like more on this side. That's the witness box. I'm just glad not to be in there. First, an apology. I got a little confused when I heard that AV was coming, and I didn't even realize I ended that last presentation like 10 minutes early, 15 minutes early. So I'm very embarrassed by that. And I think we will, we'll start this at 2:15 instead of 2:30, but we will save time in case there are more questions for Miriam and Tom before we close for the day. Or we can have a 15-minute free-for-all for questions for any of the panelists. We still have Dave is here, and Lauren and Nate, and a few other folks. So I apologize for that. That was not intentional. And sorry, Miriam, I didn't. It was a great presentation, so it was totally my fault. Okay, so this panel is supposed to be a discussion of the future of FOIA, with a special emphasis on the role of technology in trying to figure out how to grapple with those problems. And I think in particularly Jason and Sean are going to be talking about technology proper. I think Ann and I are going to offer a little more of a broader perspective on what's wrong with FOIA right now and where we need to go. So this is it's an open panel. It's not just about technology, but we're going to try to have a bit of emphasis on that. Just real quick to introduce, we have 4 panelists here. We have first Jason R. Barron, who's professor of the practice at the University of Maryland College of Information, and formerly your last spot was at NARA, right? Yes, Director of Litigation at NARA. We have Ann Weissman, who is a professor here, a professorial lecturer here at GW Law, who co-teaches the FOIA clinic, which it's great that there's a local law school. I think it's the only one that has a FOIA clinic, and also a FOIA litigator. And I guess your last organization was CREW?
Yeah, and now I do work as outside counsel for POGO.
For POGO, yes. And then we have Sean O'Neill, who's Chief of Staff in the Office of Information Policy at the Department of Justice. So thank you to our panelists for joining. We're each going to talk for 7 minutes or so, and then we'll have conversation amongst ourselves, and then open it for questions. So with that, we'll start Jason, Ann, Sean, and then myself. So Jason, the floor is yours.
Thanks, Ryan. So first I want to acknowledge the passing of Dan Metcalf, who was a larger-than-life figure in government as one of the co-founders of the Department of Justice's OIP, along with Dick Huff. Dan has a book that's 792 pages long, and it is a fascinating look at his life and career in doing FOIA work at Justice, and I recommend it. So we're looking at the future of FOIA, and that could be a few years from now, or it could be the year 2074. And think about that and what AI is going to be as part of our lives, throughout our lives, every moment of our lives over the next few decades. Let me just take a look back for a minute. Alan Morrison was here, and the Profs case, the Armstrong versus EOP case, established that email is a government record, that electronic records are important because of their metadata, and paper records are not sufficient. That led to the world as we know it today, which is when Joe Biden leaves office, there'll be more than 700 million email records representing more than 3 billion pages in the legal custody of the National Archives. They cannot be searched manually. They cannot be searched by keywords efficiently. They can only be searched by machine learning and AI in the future. So that's the first point. But then that's only a small sliver of the fact that in the government there are 300 federal agencies, and what has started with President Obama with a Managing Government Records Directive in 2011, and afterwards a memorandum and then a directive, in line with what Ralph Nader said about the Freedom of Information Act has to be brought up to date in the context of new technology. That memo recognized that new technology was important to deal with the challenges of record keeping. And so we passed a marker here in June 2024. The National Archives has gone digital. There will be no more paper coming into the National Archives. It will all be electronic or digital records created after June 30th, 2024. Think about that in terms of the accessioning from 250 agencies in the future. When we're looking at 2030, 2035, 2040 at NARA, we're in the Carl Sagan world, and I'm old enough to say billions and billions of emails and electronic records of all types, any type of media that you could imagine coming into the archives, and of course, in repositories in the federal government. And then capstone with email policies that are archiving emails for at least 7 years for agencies at large, and also for senior officials with permanent records going to the archives. We're talking about numbers that are exponentially larger than anything that has gone before in the last 50 years. So what are some solutions? The legal community for the last 15 years has had a solution. So when I was at NARA, it took me 6 months to use keywords to search for tobacco-related documents using 25 people on staff, lawyers and archivists. It took me 6 months to do a keyword search to figure out what were responsive records or not. When I was at a law firm, after I left government in 2013 and before I came to be on the faculty in 2020, that search took a weekend. It took a weekend for millions of documents to be looked at by something known as technology-assisted review or predictive coding. The legal community knows how to search for records. Some components of the government in general counsel's offices and solicitor's office also know how to search for records, but those individuals and offices are siloed often, and that there isn't a lot of interaction between the FOIA officers at agencies and lawyers. And so I am a big advocate for a kind of information governance solution where agencies look holistically at their records and data and talk to each other about what are advanced search methods in the space. I'll also say that I've been happy to be involved at the University of Maryland and with the MITRE Corporation in looking at AI on deliberative process documents to see whether AI, in the form of machine learning, can separate out what's factual and what is deliberative. And there's been a lot of success in this area. It should be extended to Exemption 6 on privacy and PII and on 7C and on other exemptions. It's not going to be there's not easy solution for filtering for sensitivities in documents. The search issue has been solved by the legal community and needs to be immediately thought about in agencies for searching for complex matters. The filtering issue with respect to finding exempt material and redacting it is a much woollier, harder problem. But there has been research, and I would encourage agencies to think about what tools exist. Finally, with respect to generative AI, there are some interesting developments in this area. First of all, Gen AI does interesting narratives. And in the future, as some of my research has shown, you could actually imagine determination letters from agencies that are generated by software with the review by people in a FOIA staff. And from what I have seen in my research, the generative AI actually does a better determination letter than a lot of agencies do in response to FOIA requests. That's one. But just, it has come to my attention, and many of you might know, that DHS, the Department of Homeland Security, has entered into an agreement with OpenAI for the use of generative AI services. And there are some issues that have come up both with respect to the Federal Records Act and the FOIA in terms of generated content about user prompts or otherwise. There is a provision in this agreement between DHS and OpenAI about federal records that there's an acknowledgement of user-generated content may meet the definition of federal records. But there are lots of questions about how Gen AI will be documented for transparency purposes. And there are lots of questions about AI generally with respect to kind of the black box algorithmic environment, and to make sure that individuals have faith that there is enough transparency in the process, that agencies are using AI methods responsibly. But there is no going back. We are not going back. I think I've heard that phrase recently. And there is no solution out there to the volume of what we're talking about over the next few decades, and what students here at the law school are going to experience in every aspect of their legal career, not just FOIA. It's AI all the way down. And so I really do encourage, as a takeaway from this day, that people think about what kind of solutions work for agencies, what are the challenges, the pros and cons of adopting it. The FOIA Advisory Committee from last term had a recommendation that the CFO Technology Council, the CFO Council and its Technology Committee look at an RFI, a request for information about AI and e-discovery, which would be generic for the entire government. I urge that committee to take that recommendation to heart. I think we can make progress over the next few years. I am not going to be Panglossian in terms of what I think about AI. I understand the challenges, but I think there is no other alternative.
Well, that was certainly rather definitive. So this program has been billed as a celebration of sorts of the 1974 amendments to the FOIA, and other panelists have talked about the role that FOIA plays in a democracy. You've heard from journalists on how they have been able to use the FOIA to promote government transparency and accountability. And I certainly agree with the theoretical value and promise of the FOIA. But as someone who has been and remains in the trenches for a long time, I admit I have a much more jaundiced view of the statute. And I think if we're going to talk about solutions, we have to first understand the scope of the problem, which is where I'm going to start. You know, I looked at the legislative history of the 1974 amendments, and two of the things that Congress was concerned about and that they hoped the amendments would address were, one, the bureaucratic delay in responding to requests, and two, the lack of priority by agency leadership in implementing FOIA. Boy, do those sound familiar. I mean, 50 years later, they are among the top problems that we face. And they're amplified by the ever-increasing volume of requests. It's higher now than ever. And what appears to be a diminishing agency resources that are dedicated to FOIA. But I think also, and maybe most significantly, there's a huge problem that Congress in 1974 could never have anticipated, something that I don't think any other panelist has really mentioned in full, and that's the role of the courts, because I believe they have turned the FOIA from a pro-disclosure statute to a withholding statute. And it was estimated in 2019, for example, and this is from Ryan, he found me the source for this, 9 out of 10 cases litigated in court are won by the government. Think about that. 90%, the government wins 90% of cases litigating under a pro-disclosure statute. I think that statistic alone, in my mind, sort of sums it up and shows just what the problem is. So how did this happen? I think Congress thought it was putting guardrails in place for courts. After all, it provided for de novo review. It provided for a presumption of disclosure. It put certain guardrails in place for exemptions. For example, with Exemption 5, it said it applied only to inter- and intra-agency communications. But the courts have gone beyond this, the text of the FOIA, to expand the reach of exemptions. So, for example, with Exemption 5, the courts have adopted the consultant corollary. There's no language in the FOIA about outside private entities being within the privilege communication of the deliberative process privilege, but we have that exemption thanks to the courts. And what about this presumption of disclosure and the placing the burden of proof on the government? It's fine in theory, but in practice, courts have come up with ways that basically eviscerate those advantages. They give great deference to agencies and agency declarations. They do not allow FOIA plaintiffs to get discovery. In every other civil litigation, if you're a plaintiff, you can get discovery, but not in FOIA, and it makes it especially hard in FOIA because there's such an asymmetrical access to information. The government has full access. They know what they have in their files, they know how they did their searches, they know what they have and why they're withholding it, and the FOIA requester is left to kind of try to pick holes here and there. It's a great challenge. You can't get discovery. And even though the government is supposed to have the burden of proof, they get a great amount of deference. And if they don't do it the first time, the courts will give them a second time and a third time. They get lots of do-overs. And all too often, courts are letting agencies get away with avoiding not meeting their burden of proof. I'll give you an example. At least in my mind, this was remarkable. I had a case. We won part, we lost part. That's a rarity. We won part. That's like that 1%. We won something. We argued in our brief that the government had not met the foreseeable harm standard. They really there was nothing specific. They just gave passing reference to it. And we said, that doesn't work. And the court agreed. The court said, yeah, they haven't met the standard. But the judge went on to say, well, I looked at the documents in camera, and I think, me, Mr. Judge Boasberg, think that there would be harm to the agency. And so I'm going to find that, foreseeable harm requirement is met here. Now, wait a minute. That's not supposed to happen. Congress imposed the foreseeable harm standard because it was concerned that agencies were overusing exemptions, particularly Exemption 5. This was supposed to be a judgment and a weighing of interests that the agencies make to determine whether they had such a significant interest that would be harmed by disclosure. To allow a court to make that judgment when the agency has failed to carry its burden, I think is just completely at odds with what Congress had in mind. Now, you might say, well, you have a great appeal issue. But no, I don't, because practically what will happen, if the DC Circuit were to agree with me, they'd remand and say, agency, you do a declaration. And what's the agency going to say? Exactly what the judge found. So, but it's just an example of how I think courts have gone out of their way to turn FOIA ultimately into a withholding statute. They have ignored the text of the statute. They have imposed their own judge-made limitations. They have not, I think, complied with the spirit of the FOIA that starts with a presumption of disclosure. And the net effect is that the government wins 90% of the cases. Now, I think there's a kind of interesting question. It's probably beyond the scope of this panel. Now that we are in a post-Chevron era, what does that mean for lawyers? The typical deference that has now been eliminated that's given to agencies, will that have an impact on how courts treat agencies under the FOIA? I think remains to be seen. So what are the solutions? Well, let me start with AI. I am a Luddite. I don't like technology. People who know me know that. I accept Jason's premise that with respect to searching, AI is the solution. But where I start to have concerns are when we talk about what he labeled filtering. Because what I think is going to happen is that AI will turn into yet another tool that courts will completely defer to with respect to deliberative process. If you want to extend it to Exemption 6 and Exemption 7C, I think all the government will have to come in and show that their AI program conforms with some, industry standards. And so it will be yet another way in which courts have a tool to make the FOIA a withholding and not a disclosure statute. So I am very wary. I'm not saying there are no solutions. So I don't have a solution to the zillions of records we're going to have, but I think we have to be very cautious with AI as sort of the panacea or the bright, shiny object that it's being portrayed. In terms, I have some more smaller solutions. Katie from the Reporters Committee talked about how they do impact litigation. Given the trend we're seeing and how I think courts sort of individually and collectively have perverted the FOIA, I think maybe some of us who do impact litigation should try to think about if there is a way to formulate some kinds of challenges that will bring some of these more egregious practices to light. I mean, I say that warily because I don't have a lot of confidence in the Supreme Court, although only a very tiny percentage of FOIA cases ever get to the Supreme Court. I think there is a role for Congress, but in the past, I've always looked to Congress to be the savior, and now I think it's just one part of the solution. Certainly, we need more money. I think that no one will disagree on the idea that FOIA is atrociously underfunded, and without money, they don't have the resources. There's been some talk here today about Exemption 5 and the deliberative process privilege. I would eliminate it entirely. And I say that because I think it is fundamentally at odds with the purpose of the FOIA. FOIA, as the Supreme Court has told us again and again, it lets the government know lets the people know what the government is up to. The deliberative process privilege is a barrier to that precise information because the deliberative process privilege protects us from learning what went on behind the curtain. But that's exactly the information we need to understand the actions and policies of our government. So I think it has no valid place in a true FOIA scheme, and it should be eliminated. I also think that we need to think of some other creative solutions. I don't know what Ryan's going to talk about, but he and I and some others have bounced around the idea of having a FOIA court. And maybe that's a way to overcome the resistance in the district court here to implementing FOIA as it was intended. In fact, at times we've seen outright hostility to the FOIA. There is a judge who wrote a decision, and he singled out several nonprofit organizations in the DC area and basically said they were to blame for all of the FOIA litigation and the backlogs because they brought a disproportionate number of FOIA requests. Well, Margaret Cuoco has done a brilliant job of collecting statistics and talking about this, and she said that the greatest FOIA user is actually commercial users. Nonprofit groups and journalists are a tiny, tiny percentage of FOIA users. So, but that just reflects, I think, a real hostility by some courts to what the FOIA is intended to achieve. And, depending on what happens next week, that could portend really bad things or really good things. We'll have to wait and see. But for me, and I'll stop, the bottom line, I think, is that we do need a fundamental reset. I think we are at the sort of inflection point. If we don't get more funding, if we don't consider more radical and fundamental legislative changes to the statute, and if we don't come up with a way to stop the courts from perverting what the FOIA was intended to be, I think the utility of the statute, is going to just get weaker and weaker.
Okay, thanks for having me here. I'm going to be slightly more optimistic than Ann. That's me by nature, I guess. I've been at OIP since Dick Huff was there, so I guess that was like 100 years ago. It's been a while.
104.
Yeah. So I want to talk a bit about AI today. And I also have an optimistic view of what it can do here. So obviously, government transparency laws are a crucial part of a functioning democracy. It's kind of shocking we didn't have the law until the 1960s, actually. But the enemy of requesters and agencies often is time. Just the time it takes to wait for your request to get fulfilled, the time it takes the agency to get through all the steps it takes to process a request. Especially for a requester, I can imagine, who's writing a news article or something. That's got to be difficult when you want that information quickly. And from the government's perspective, which I think I'm the current representative who's from a government agency, there's a couple reasons for that, the time and the time that it takes. Number one, as has been mentioned, over the past decade, the number of FOIA requests has increased by 70%. And they've gotten more complex as well on top of that. The number of FOIA personnel in the past decade has gone up 28%. So those two lines are kind of diverging. They're not staying together. And the other big part of this is that that work it takes to process FOIA requests, it takes a lot of time, especially on the complexity. And I'll start with the search. Now, we've talked about some search technology solutions. At DOJ, I hate to say, but we're a bit behind the times. We're trying to catch up, and I'm trying to help push that along. Searching for records, first you get that big pile of documents that's the potentially responsive stuff. That's the keyword search where you find that big pile of records. Then you do the second part, which is go through that smaller stack to figure out what's actually responsive. In practice, we find that only 5 to 10% of that big stack is actually responsive to the request at issue. And we recently had contractors do this for us at our office for a bunch of Trump-era records. And to go through hundreds of thousands of these pages of emails, it cost us hundreds of thousands of dollars and many months of human effort to get that done. So we have a pretty good baseline there of what the human cost is to do this that we can then compare to what the AI will be. Review of records for FOIA exemptions can also be very time-consuming, depending on the size of the request again and the nature of the exemptions. Also, if you have to do consultations, that's time-consuming. I've got a request in my office right now, one of our oldest, where our analyst is having to do 63 consultations with different agencies. Just the work of getting all that together and getting all the responses is just an enormous undertaking. So review is very time-consuming. Even the administrative stuff, opening and closing requests, figuring out what the requester is asking for. Did they ask for expedited processing? Did they ask for a fee waiver? Is it justified? All the administrative stuff takes a lot of time too. So what would a more ideal FOIA process look like? So this is going to sound like science fiction to some of you, but I would say that if we looked about a decade out from here, in my ideal world, a person would make a FOIA request, and a few minutes later, they would get a response. The system will have conducted a search for the records, figured out what's responsive, applied FOIA exemptions, and then printed it out, sent it to the requester, right there on the spot. Now, that seems like a long ways away, but I do think that based on technology that we already have or that's currently in development, we can see steps being taken in that direction of that happening. And I won't be surprised, honestly, at all if within a decade we have that capability, and the only thing holding it back would be just government willingness to be okay with an AI doing that much autonomously like that. So I wanted to think about a couple of ways AI can be applied in each of these areas we've talked about: search and review, administrative, all that. As for the search and responsiveness review, as my colleague up here already mentioned, there's already coming online great search technologies that allow you to conduct big searches and get back results a lot more quickly. And generative AI combined with that is going to be even better, where we'll be able to have that initial preliminary search and the second responsiveness review all kind of done in one step very quickly. That will pose a challenge for courts. We've talked a bit about courts. They're used to adjudicating the adequacy of searches just based on keywords and, what search terms did you use, where did you look, that kind of thing. Courts are going to have to be able to make the mental shift to, rather than looking at what keywords did an agency use, they're going to have to learn to adjudicate AI prompts. What was the AI prompt that the agency gave to the AI, and we have to adjudicate the search using something like that instead. So courts are going to have to grapple with that. As for review of records for exemptions, we've talked some about that as well. Just in the past month, I've seen a demo from a vendor where they are able to apply Exemption 5 and Exemption 6. I would say that the demo they showed us was relatively easy context, but it was more impressive than I thought it would be, actually. And they're going to get better and better, obviously, in the coming years. Those of you who've used ChatGPT, Google Gemini, Claude, those tools, their power comes from their broad knowledge of the world. And that broad world knowledge is exactly the kind of knowledge that you have to bring to bear to be able to accurately apply FOIA exemptions to records in the FOIA context. I honestly think we'll see agencies starting to dip their toes into applying exemptions in the FOIA context using AI in the next 1 to 2 years, with much more broad adoption probably within 3 to 5 years. What isn't as clear to me is how long it will take until AI gets so robust and so good that we'll be able to kind of just push the button and mostly rely on it and not have to worry about it. That's probably 10 years away. Honestly, it's not as long as you might think. And I think we'll have humans in the loop for quite some time to come. But this is coming faster than we think. Likewise, for the administrative work of processing FOIA requests, there are already AI agents coming online that can do customer service, that can communicate with requesters, that can do some of those things to help agencies better serve the public. Now, agency adoption of those tools is still very, very small, but it's going to grow. In the near future, companies like OpenAI, Google, Anthropic are planning to release tools that allow AI agents to do pretty much anything on a PC that a human being could do. Now, those tools are still in their infancy, but they are coming, and they're talking about it in 2025 as a big, big thing that we're going to see. And that's going to be incredibly capable and incredibly useful for tasks like opening and closing FOIA requests, responding to requesters by drafting response letters. Even things that would seem more difficult, like compiling a FOIA annual report that gets submitted to DOJ and to Congress. I think it won't be long before AI is doing most or all of that work. In summary, what's exciting about AI and FOIA is that while most of these things I've talked about are not yet commercially available, a few of them are, and virtually everything I've talked about is going to be feasible with just a generation or two of improvement in the technology. Now, a little caveat here for those who are nervous about technology, there's good reason to be nervous, and this could slow things down. Agencies generally are slow with technology anyway, but some of the risks of AI, too, should be taken into account. Those of you who've used some of these tools know that they're great at writing and creativity, but they're not so great at factual accuracy. I can't tell you how many times I thought, boy, I wish there was a FOIA case that said X. And I asked ChatGPT, and it says, yes, there is a case that says exactly what you need. And I'm like, great. I pull it up, and it doesn't exist. There is no such case. It made up the case name. It made up the citation. It was all fake. So there are issues like that still. They call that hallucination. Yeah. AI models do hallucinate sometimes, and so that's something they need to work on. Researchers are also working on AI alignment. AI alignment is the idea that our AIs should have values that are similar to our best human values. And there's a lot of research going on there that needs to help that come along. However, despite the hallucinating AI model, I am very confident about the future. The future is very bright. And even if you're not, if no one here is planning on pursuing a career in FOIA or is a FOIA attorney, the same technology that's going to revolutionize AI in FOIA is going to revolutionize the legal field as a whole. Many large law firms, I just saw an article about this week, many large law firms are starting to rethink the billable hour model because there's things that they used to be able to have their paralegals and their attorneys spend hours or days on and bill for that time that are now taking seconds. And so they're thinking, well, maybe we should charge a flat rate instead. So there's a lot of people thinking about this stuff. And one thing I just want to say in closing is that it's worth remembering that technology does not progress linearly. So we, as human beings, we tend to think linearly, where things kind of go up in a straight line. Technology progresses exponentially, which means that it's like a doubling. You know, instead of just being a straight line, it's doubling every year, whatever the doubling time is. And when you think about what we've got now compared to what we had 2 years ago, it's astounding. What we see these chatbots doing now, 2 years ago, we would have thought it was a science fiction movie. Likewise, 2 years from now, things that we currently think are impossible are going to be feasible. And I think it's going to be great fun, and I look forward to seeing the AI revolution may have a great positive impact on government transparency and in many other areas. Thank you.
All right. So I'm gonna try to be halfway in between Ann and Sean and Jason in having a little bit of.
Don't include me with Sean because I have a different point of view.
Okay. But in terms of being generally optimistic about what AI can do.
Mildly optimistic.
Mildly optimistic. So I would agree that it's first important to point out where I think some of the problems are right now with FOIA, what's bad, what necessitates some sort of reform. And I would definitely, obviously, we're dealing, Miriam, I think you gave the statistic that we've hit over 1 million requests. Jason, you mentioned the number of pages of federal records that are out there. And let's remember that the definition of agency record under FOIA is broader than a federal record as defined by the Federal Records Act. So just the amount of stuff that's in there, out there in the world, and the new types of records that are coming up, including, I think especially what's interesting to me is automatically electronically created records that might be around in agencies, like recordings or transcripts of Teams meetings and things like this. There's just so much out there, and more people than ever are trying to get it. There's a lot. And the funding issue, which everybody has mentioned, is obviously there. I would agree, too, that the state of the courts and of judicial review is a huge problem. I mean, I always like to talk about the oddity of FOIA. I mean, it's administrative law, but it's really not, right? We don't get administrative records, but then we also don't get discovery. We have de novo review, but then we have informal deference and only a 90% win rate on the side of the government. And then we have this whole phenomenon of FOIA fatigue, which Katie had mentioned, which I think is a real thing in the DDC. And as a litigator, Tom, you mentioned how in the 74 amendments, together with the shortened deadline for an answer, there was a provision that said unless a court deems otherwise another case should take precedence, FOIA cases are supposed to be immediately scheduled for a hearing and to be expedited in all ways possible. That was taken out, I don't know what amendments and took it out in the 80s or 76? Okay. So that was taken out. And now we have a world where, I mean, obviously the DDC is buried by January 6 cases and other sorts of things that are going on. But my sense, and this is only anecdotal, is that FOIA cases are given very, very low priority. And there is a hostility among some judges to that. And you mentioned that opinion that singled out public interest nonprofit groups. Professor Bernard Bell at Rutgers had a great number of essays on Yale Notice and Comment, the blog, kind of countering that and citing Margaret's work about why that's just a mistaken perception. I think we're in a bad spot right now, and I think this is not insignificant. I mean, it's a real problem, is just the state of our political culture and the culture within agencies and in the dynamic of how requesters and agencies are dealing with one another. So there's obviously tension at times between FOIA offices and program offices. There's tension between FOIA officers and political leadership, and that doesn't change from administration to administration. Some administrations might be worse in terms of their view of how FOIA should be implemented. But then I think there's also been a weaponization of FOIA and FOIA processes, and that goes both ways. I think we've seen, and some people have hinted at, there are some requesters out there who, you might argue misuse FOIA and negatively impact the operation of FOIA offices and the morale of public, of access professionals at these agencies. But at the same time, I think there is a reality of things like misuse of sensitive review processes or awareness review processes where requesters are unfairly targeted by agencies and their responses are delayed. So we have a lot of issues. I am more optimistic than Anne in that I think one nice thing where we are now is more people than ever know about FOIA. You hear about FOIA in the news. Yesterday in an event Lauren and Tom and I did with Freedom of the Press Foundation, I mentioned how the Presidential Records Act and Federal Records Act scandals of the past two administrations, I think, have really brought a lot of attention to the importance of federal records management and the fact that the records of the government belong to the people. That's not directly FOIA, but there is some relation there. And I do think, and this is something that Katie said, that the text of the FOIA, set aside court interpretation of it, is still pretty solid. And compared to where we were before 1966, FOIA is leaps and bounds better. I mean, one of the best is that you don't need either constitutional standing or prudential standing the way you did under the APA Section 3 public access provisions. You could just file your request, and if you're dissatisfied or you don't get a response, you can just go to court. I think that technology and AI is inescapable as becoming a part of FOIA administration. but I have a few quick thoughts on that. I think generally there has not been a lot of attention paid to the ethical issues associated with the use of AI, particularly in the context of legal challenges and litigation. And I just heard Professor Josh Blackman at Scalia Law talk about this a bit, about when the use of AI might bleed over into the unauthorized practice of law and concerns there. And I think those are indirectly implicated here in our discussion of how AI might be used in FOIA, particularly in litigation. But that's an area that's totally underexplored, at least as far as I'm aware. And I'll admit I'm not an expert in this and haven't done some of the research that others in the room might have done. So that's just an atmospheric point, if you will. I'm a little worried about, to the extent AI tools are incorporated into FOIA processing software or otherwise, the abilities of programs are set by companies, and those companies come to predominate the FOIA processing market, that the limitations set by those companies then dictate the limits of what the government is able to do and therefore impact, at the end of the day, the rights of people to access information. And this is not speculative. I mean, I've had discussions with FOIA officers where I've said, I want these records, and they're very open. We have a great conversation, and I say, well, can't you just do this and this? And they said, well, no, our FOIA platform doesn't allow us to run the search that way. Well, but you could do it before, but now you've switched to a particular program. And, I think now you have, there are a few, there might be one company that dominates the market. I don't know the statistics, and I won't name the company, but that's a little troubling to me, just practically. I would say AI, the use of AI by agencies, I think has a lot of promise for search and responsiveness review. But I'm definitely more concerned about its use for the use of exemption review. There's a broad principle that FOIA's exemptions are discretionary. Some might quibble about which really aren't discretionary. But just because something is technically exempt doesn't mean it has to be withheld. And even if something is technically exempt, there's still the foreseeable harm standard. The requirement for there to be some sort of discretion, I think legally needs to mean that there's a human mind involved, and that could be reviewing what the AI has already initially processed. But I think that you're going to end up in a situation where the default is just kind of to accept what the AI has done. And in that respect, to push back, I think, Sean, to respond to one of your points about judges reviewing AI prompts, I don't think that's going to happen. I mean, having heard Magistrate Judge Facciola for a long time talk about e-discovery, as I understand how he's described how he would handle a future where these sorts of tools are used is, the agency would say, here's an expert's report about the efficacy of our software. We've determined that it gets to the right answer in 99% of cases, and the court is going to say, well, you get a presumption of good faith in your declaration offering me the expert report, and unless the requester can provide hard extrinsic evidence to counter that, that's it. And the agency wins. I would just say one final point on AI that I don't think I heard mentioned, or Sean, you might have hinted at it, is I think it holds promise for the use by requesters in drafting better requests and in helping mine information from the internet about custodians, the structure of government, component offices, and in maybe even helping. I mean, I would be interested, Jason, if you could speak to, you mentioned how AI writes a darn good determination letter. How does it fare in writing requests? And how might that be a way? I mean, OIP's wizard is great for helping people find where to file requests, and FOIA.gov, I mean, it doesn't have an AI prompt, but it kind of has something like that where you can kind of get to where you need to go. I wonder if there are ways that it can be used to help requesters draft better requests on the front end.
Can I say a few things?
Yeah.
Yes, and actually there's a growing concern in some agencies that they're getting bombarded by AI-generated FOIA requests, and so that's something that the FOIA Advisory Committee is going to take up during this term. Let me say that I attended the 1964 World's Fair, and I was promised that cars would glide over highways in 1980, and that we would have cities underneath the sea and on the moon by 2000. So Look, Sean, your dream. I absolutely am with you, and you're going to see AI more than I will. I will have retired and gone off to an island somewhere. But it's not 5 years. We have, these are exceedingly difficult issues to deal with. And in terms of exemptions, and I am absolutely 100% with Ann that there are issues here. There's also a kind of meta-contextual problem with foreseeable harm standards, which is that AI, they can look at documents and pattern match and figure out what is deliberative or figure out what is personal information. We can solve some of that, but you need human review because you need foreseeable harm to be put in, and that's not within the document itself, it's within the mind of people at the agency. And so there is not going to be an automatic thing where 2 minutes later there's a software search, a redaction, and out to the requester. You need what Ryan said, which is you need human review to put that contextual element in it. But you can quickly expedite a process. And I am sure you would want a process rather than an agency says, we are going to take 5 to 10 years and we'll give you 250 pages a month, to shorten that period because they've searched through 1 million documents and they've come up with at least a set to then review, hopefully with the algorithms that Sean and I are talking about, but with human review, sort of, it's faster, even if I agree with your concerns that courts might defer unduly to an agency's set of declarations that say the software determined this. And so there's always that danger, and I have a lot of concerns about the courts going forward. In any event, I think that my experience, and I have lived this in the e-discovery area, both in government and private practice, is that it takes much longer to get to a point of maturity with these methods. The e-discovery community, some of us were evangelists in 2010, 11, 12, when the first e-discovery opinions came out and said, this is the new thing about machine learning technology assisted review. And we were expecting that within 5 years or 10 years, the legal profession as a whole would be adopting this as a better way to do legal searches than keyword searches. And I've been on a platform for this, but it didn't happen. And there's sort of massive resistance on the part of law firms and other stuff to change their business model. And those that are the best law firms in the space that are saving clients money are using AI. And what I was saying is that you can translate that into the government experience. Some lawyers in various general counsel's offices use it for search. There are woolly problems with exemptions. And so I believe there is hope. And Sean and I, we're on the same page that there's hope. There needs to be a lot more in terms of vendor development and tools. We will get there. We will get there. But it's a process where I just want to plead that agency personnel are aware of the issues, that at least the conversation that we're trying to have on this panel, to have a conversation with their procurement people and their lawyers and whatever, and not be siloed as just a FOIA office doing the same old thing that they've done for decades. So that's what I'm interested in, have an enlightenment that there are these possibilities. And if OIP leads the way, that is wonderful. But that conversation is not happening in many places. But we need the conversation. We need the commitment of resources. We need to have awareness, as Ann says, of what the reality is about what can be done with respect to AI and with respect to human review and all of the resource issues that have come up today. And then we can make slow and incremental progress. It's not going to be like this. It's not going to be 5 years. It's going to be through decades to come. But the problems, just think of the world of 2034, 44, 54, 60. You know what is going to be government then. It's going to be filled with a universe of applications, a metaverse. Think of smart glasses generating federal records. Think of anything that you can imagine that you read about in Wired and whatever place online. This is all, if it's about the business of government, it's going to be federal records and presidential records. It's going to have to be accounted for by NARA and by every federal agency that exists. This is the world of tomorrow. It's not going to be cities under the sea in 5 years, but it is going to be our lives. And so this forum is a wonderful one to have a starter conversation and to take back, to the extent that there are federal people listening in this and other forums, to have that conversation going forward. Enough evangelism.
Sean, Ann, any thoughts?
I don't disagree with you on, locating responsive records, not at all. But as I said, I fear that in the end, it will be another tool that will turn the FOIA even more into a withholding statute.
Yeah, I mean, the thing is that what it is, and so my research and whatever, is that what it does is AI weights. Keyword searches, you get 1 million hits, 100,000 hits, whatever, and they're not weighted. The thing about searching for redactions and searching for responses, searching for redactions, is that you have kind of a weighted sample. You know what are the documents that are most likely to have exempt material, and that can be reviewed faster and determined in that way. It is far from perfect in any kind of software. And it's just what it's saying is that you can make progress in this area beyond manual redaction the way it was done in 1985, which is the experience that I have as a frustrated FOIA requester in getting responses from agencies. It shouldn't be 1985. We should have manual review processes. There should be intelligent assistance aiding in human review, not to have the software spit out the answer, but to do something that is kind of a hybrid that makes sense and can be defended in court by the division that you and I used to work in.
So if I would just remake the final point. Putting AI aside, and I recognize that it may offer one of the most effective tools we have to get past the bureaucracy that we're facing, but we shouldn't lose sight of the fact that that is not the only problem with the FOIA. That is not the only reason we don't have a better FOIA. It's not the only reason that we're ranked. What are we ranked? 70-something, whatever it is, in the world on effective FOIA. And we should not lose sight of the fact that technology may provide part of the answer, but it's only part of the answer. And I still maintain we need very systemic change for the FOIA to live up to the promise of 1974.
Yeah, I mean, I agree that at least the things I've talked about don't fix some of your concerns. That what I'm talking about, technology will make us faster. I hate as much as anybody when we have 3, 4, 5-year-old requests. But I meet with the people processing these regularly, and I can see why they take that long. Going back to that 63 consult requests that we have, those are consults out to national security agencies and law enforcement agencies. And each of them have their own interests at play there. So I do think FOIA can make it faster, though. To the AI prompt part, I'm going to defend myself on that. I do think it's true that we'll probably get declarations attesting to, how solid is the product they're using and how good is the AI it's using. But part of this is always still going to be the AI prompt, which is kind of the smart version of what used to be the keywords, right? It used to be, here's my 20 keywords I used. This is going to be, what is the plain text description of the subject of the request that you fed into the AI? And did that look to be reasonable? I think that's still going to be a factor. So,
Do we have questions? Okay, Nate was.
Thanks. It's really interesting. It's pretty easy, and I did it in my panel, to say we need more resources, and everyone says it, and it's true. But what I don't hear quite as much that's equally as true is in many, if not all, FOIA offices, there are extreme inefficiencies. So I think getting that truth out there, and I think this panel kind of implicitly recognizes that and gives some possible solutions. For example, a document should not need to be read by 63 sets of eyes. I mean, that's an inefficiency. It should be read by one, probably. So, but to my point, that the thing that gives me the great pause, going back to something that's come up in every panel today, which I think is good news, is Exemption 5's pre-decisional process. And I'm going to mention it again. With this lack of resources and being a discretionary exemption that does not have to be reviewed and redacted, why are we using our precious resources to discover this, to withhold information that the requesters think should be out in the public, and previous attorney generals had said, stop denying this information. So I guess it's a much stronger point to say, find 9 digits and redact the social security numbers quickly. I'm close to sold on that, but I'm not sold on saying, oh, we just helped the agency target 500 pages that could possibly be easily withheld from the public. It just seems like not a good use of resources.
You were looking at me. So,
well, you talked about using AI to find pre-decisional information to exempt it.
Yeah, no, right. I'm going to be somewhat agnostic on the legitimacy of Exemption 5. It might be somewhat contrary. But let me just say that, just as a side note, Congress has eliminated Exemption 5. It did so in the Presidential Records Act, and there is no B5. So after 12 years, there is a P5 for executive decision-making with senior officials, but for presidential decisions, but not a B5. And you know what? What I was talking about 700 million emails from Reagan to Biden, and I want to clarify it was the entire span, those are not going to be available to the public for 75 years unless you have FOIA or litigation. And it's all because of personal information PII. So it's not deliberative. So you have a non-B5 world and you still have all these issues. So that's coming from. And also the fact that B5 has been eliminated by Congress for the 25-year mark. And National Archives, they get records traditionally at the 30-year mark. B5 is eliminated, but if they're getting billions of emails, B5 is eliminated, but it's still, you have this huge volume. So I come from a little bit of different perspective where we need AI, we need these tools that Sean is advocating and I'm advocating, because and it doesn't really make a difference whether B5's there or not, but I do understand the point. And I'm very sympathetic to a conversation that goes way beyond AI about what the point of deliberative withholdings are. I shall say, and Dave would appreciate, there are dozens and dozens of deliberative process statutes around the world that is exemptions to FOIA litigation internationally. And so countries have come in an open government area that there's still this exception. So you're going to fight this battle, and it's a good battle to fight, but it's not, the U.S. is not alone in that. There's some legitimacy to the need for candor of decision-making in government. Is it overused? Of course it is. And I am, very sympathetic to that, but I'm holding out for a core reason like this.
To be clear,
one quick factoid, sorry. There are many states that don't have it, and to not the detriment of the state, to the benefit of the citizens of those states, in my opinion.
I agree.
They're
to be clear, it doesn't all go away after 25 years.
What's
deliberative process?
Only deliberative
goes
process.
away.
Yeah, deliberative.
Attorney-client, attorney-work
Right.
product. That's
No, we're just talking about.
okay. Yeah, so B5, that part of B5 goes away.
Yeah.
Tom, do you have a question?
Moving away from AI for a minute, I want to address Ann's doom and gloom perspective. Ann Weissman is one of the premier FOIA litigators in the country. So if it's easy, you don't get these cases, all right? I mean, why go to you if, someone like me could resolve those things? So, it does seem to me that your pessimism may discourage students, community groups from using FOIA because Ann says, oh, it's broken, it doesn't work, it's terrible. The fact is that majority of requests are honored, at least in part, a large number, 30-something% in whole. More and more, FOIA is forcing more and more information into proactive disclosure. So I'm not saying it's working wonderfully, I'm just saying that,
The glass is half full. I hear you. No, I'm not. Look, I'm not telling anyone don't use the FOIA. I've been doing this work for decades. I still stay in it, and there's a reason. I'm trying to make the statute better. And like Katie, I think if you read the statute, on paper, it's a great statute. but I also think it's been perverted in a lot of ways. And I'm just not going to go quietly. That's all. I mean, and that's why I say, you know, when Katie talks about impact litigation, I'm very serious. Like, if you have any interest in maybe seeing if there's a way we can bring a lawsuit to change some of this direction, you know, give me a call. I'm all in. I'm not saying walk away from the FOIA, but I am saying let's fight harder to make it even better.
So we'll take Daniel's question, and then I want to open to questions for Tom and Miriam and for the other panelists and just general Q&A for 15 minutes. But Daniel, go ahead.
Thank you. And I don't project very well, so if folks can't hear me, please let me know. So there's a lot of conversation around AI, I think in part because the idea is that it would bend the cost curve and bend the time curve. But what we're also hearing is that there is insufficient resources. So I had a couple questions, which is, one, what would be sufficient resources? I mean, I haven't looked at the funding level, the cost to government, but I think it was, when I looked at it last, it was $500 million a year for implementation of FOIA. 10% of it was litigation costs. I could be wrong. It's probably different now. What should that number be? Where should those funds go? And who is advocating to have this increase in budget put into the president's budget or to the appropriations subcommittees?
So I have a few thoughts on that, first of all. That may not directly answer your question. So I can think of, in the past 2 years, 2 pilot programs where there were direct appropriations to agencies for FOIA. So there was Department of Veterans Affairs and Department of Homeland Security. I think those are the 2.
Interior.
Oh, Interior. I don't remember the exact numbers with any of those agencies, but they might offer some perspective on whether the funding levels were adequate for an agency of their size and given the complexity of their request. So that might be someplace to start. I think that my personal view, and this might be controversial, is that in addition to maybe line item, the whole fee structure of FOIA needs to be overhauled. And I think I am open, I have heard, and being a requester, I know this is crazy, but I'm open to just restarting with fees, requiring a flat fee for everybody, not having preferential fee categories, and then just having a very robust public interest fee waiver. So that at least, and have the fees go straight to the agency, to the FOIA office for use with FOIA administration. And then, you know, that's not going to self-fund those agencies, I don't think. Maybe a few of them that have heavy commercial requester use. But I think that would simplify a lot of things to allow agencies to, because some agencies, they just don't bother, right? 2016 fee restrictions aside, they just don't see it as worthwhile to collect the fees. That's beginning to change from what I hear. But that would be one change. I don't know who would be the one in Congress to propose, or in the executive branch. I can't answer that question.
Last time I looked at it, FOIA fees were $6 million. So, like, even if we
Yeah, but agencies aren't collecting fees.
Yeah, but it's $500 million current cost, and we're talking about increasing to some unknown number. I don't disagree with it. But I'm trying to figure out what is that goal, and then who out there. I mean, because I'm watching. You know, this room should be packed. We should be in a bigger space. You guys did an amazing job putting this room up. But like, I look at the diminishment of our community that's doing this advocacy work. And there was conversation earlier about like the news organizations not making alliance with the open government organizations, not making alliance with the other folks that are involved. I'm just trying to think of if the crucial issue, or if a crucial issue is funding, and there is some bigger number for funding that we need, and there's fewer people out there advocating for funding, or nobody out there advocating for the funding levels that we think we need, then I think we're at what Ann was talking about, which is a crisis where things have to fundamentally change in a different kind of way. And it's not this system that we're talking about anymore, but something else.
But I think there's another dimension to this, which is that right now there are no penalties for an agency not complying with its statutory obligations. I mean, Social Security has to cut those Social Security checks, right? It can't say we don't have enough money to do it. If agencies had if there was a stick or a carrot, however you want to approach it, they might do a better job of finding the funds. A lot of agencies, my understanding is their funds are buried in like public affairs offices. They have no incentive to apply greater funding for FOIA. Number one, because they don't suffer any really adverse consequences by not doing it. And number two, they don't like FOIA in the first place for the most part because disclosure is not always a friend to agencies. So
You're not talking about FOIA officers. You're talking about program staff
yeah,
and
I'm
politicals.
talking about programs. So I'm just saying, yes, we need more money, but you also have to address the fact that right now, another way to look at it is there are not sufficient incentives for agencies to comply with FOIA.
All right, I want to open the floor to free-for-all questions on anything, and I'll turn the other mic on in case we need to pass it to one of the other panelists. Claire, if you want to take it. There was a question back here.
My question is, how about restricting the number of requests from certain nonprofit groups that send hundreds of FOIA requests, many of them potentially frivolous, for hundreds and hundreds and hundreds of documents that don't seem to have an actual focus. They're what are called fishing expeditions. Thank you.
Could you hear that?
We heard. So the question was, is there a way to stop particularly, identifiable requesters from filing frivolous requests?
Well, all requesters, but some agencies, some organizations do a lot of that.
I think what she's suggesting is each agency ought to have a list of 10. Other than that, no.
The FOIA Advisory Committee this term is addressing something like that in terms of, given the frequency and complexity of requests. And, there are states that have what are popularly known as vexatious requester standards where they can reject. I think Connecticut, there have been a couple cases that have come up. Utah as well. So that's something being addressed. I don't know if any of our panelists want to speak to that. I would just be worried about the abuse of such a standard.
Yeah, I mean, I think a lot of us know about the Heritage Foundation story. I personally get heart palpitations thinking about giving the government more of a leeway for defining a FOIA request as frivolous. I think that leads to potential unintended consequences that we're not perhaps thinking about when we're looking at, these kind of very partisan, potentially frivolous FOIA requests. So I'm skeptical of going that route. I'm not a fan.
I'm going to take the prerogative to ask a question of Tom and Miriam, which is that if you had to identify, looking back to the 74 amendments, if there are 2 or 3 preconditions that we need to achieve to have the same sort of monument, and you may have already addressed this, so maybe you just recap. What do we need in place to have the same sort of shift that we saw with the 74 amendments? I mean, is it like what Daniel's saying, we need to have a broader alliance between stakeholders in proper FOIA administration? What is it that we need to get our own 1974 in this age?
Well, I don't know that I can come up with 3, but actually I think Daniel's suggestion is a good one, and that is we do somehow need to build a broader coalition. 2, I think if we could get back to, and I talked to Nate about this after his panel, if we could somehow have media organizations do a better job or partner with some of the nonprofits to really put a push out there for letting the public know why these things are important and how they do affect things like food safety and some of the things that our first panel talked about. I don't think people actually understand, not only is this something that's good for America, but it's also something that's important. It's vital to communities. It's vital to to all of us as people who live here and who eat, drink, ride on the highway. All of those things would be a huge start. And we had a cataclysmic event in this country in the whole Watergate and everything related to that. There was outrage. There was a fervor for disclosure and letting people know what their government was up to. And I'm not looking for a cataclysmic event, but something that reminds people that this is absolutely something that we have to have for good government.
Tom, do you have anything to add to that?
Can somebody?
First, on the subject of cataclysmic event, we did have a Nixon impeachment, Watergate, et cetera. It may be that if we have a president who is hostile to open government and bent on destroying agency integrity and independence, that will be enough of a catastrophic event that in 4.5 years we will actually have a major drive to reinstate a much stronger transparency regimen. The other thing is a question of moving forward, what's the thing we need most, both inside and outside government? Money, resources. We've talked about that for agency needs. Going back to Ralph Nader, I remember